I think we're ready to begin. I'll call the meeting to order. Secretary will call the roll.
Chairperson Barney.
Here.
Vice Chairperson Llewellyn.
Good morning, here, thank you.
All right, we're back in session. Are we recording?
Yes.
We are, yes. So the roll call got on the recording? Okay, great. Good morning, everybody. Of course, we did receive from the parties yesterday from both sides their supplemental materials, briefs, motions that they filed yesterday. What first we're going to do today is try to clarify, first of all, what motions are already ruled on, what motions might have been discussed but are not yet ruled on, and if there are any that are pending, for example, and then, of course, what was filed yesterday are pending. In some cases, I know motions have been filed to reconsider some of the rulings. So just from the party standpoint, I want to make sure we're clear. So, and we have a long list of motions. I don't know if they'd be, a plethora would be the right word, but certainly might apply. I'm going to start out with the list that I had that at the beginning of the hearing we discussed. Now, I know that the attorney for Ms. Gray has objected to the fact that the commission met the two commissioners with the hearing officer and discussed all the motions that had been filed before the hearing and agreed on certain rulings on those, which I announced at the beginning of the hearing, and the personnel director has objected to the fact that those were not heard at the hearing itself. So we want to go through those. First of all, I believe, was a motion to quash the investigation. Is that correct?
Yes.
Mr. Norwood?
Yes.
You know what? So, briefly, do you want to make your argument on that motion? In other words, what investigation are you referring to, and why do you think we should have ruled it should have been quashed?
Well, thank you. Good morning. That motion is a motion that we filed back in October, along with, I guess, the other motions you're going to cover, which include a motion to disqualify the city council's office. There was a motion.
Right, well, we're going to go through, I think,
Okay,
all
we're
of
gonna
it.
get through it. All right, on the motion to quash the investigation, it's our view, and this is one of the reasons why we want to call Comptroller Darlene Green, is that this whole process is one that the Board of Aldermen has directed should be handled in accordance with the whistleblower ordinance. There's been testimony about that in the record already from Dr. Byrd with respect to that process. Our view of the world is that when the legislative body of the city, in the form of the Board of Aldermen, enacted this whistleblower ordinance, they designated a process by which certain types of complaints, and our view is this is a whistleblower complaint. We've got record testimony from Ms. Lambert that she was the whistleblower, and therefore it should have been on a whistleblower track, and that track requires the matter be disposed of by the city comptroller, and it was disposed of by the city comptroller when she accepted the $170.30 and advised her that this is how it's normally handled. Have a nice day. And that's how it should have been resolved. But, of course, we're here today trying to suggest that that violation, unknowing violation, constitutes malfeasance that justifies removal from office. So we briefed that in the context of the motion. We cited the provisions of the whistleblower statute, and we believe that that statute should govern. We believe that this body, as determined by the judge a few floors down or up, I forget, that suggested that that's for the commission to decide. And we teed it up to the commission back in October, and we believe that had that process been followed, there would be no need for us to be here today. And the only reason we'd be here is another, we believe, more evidence of the fact that the Board of Aldermen be darned, the whistleblower ordinance be darned. I've got a vendetta against this director, and therefore we're going to play by my rules. The heck with the ordinance and the heck with what the alderman has suggested, so that we believe that this body can and should reject this whole process today, direct that it be put on the whistleblower track today, so that we can then proceed in accordance with what the ordinance and the legislators of this great city have decided how this matter should be handled.
Any brief response, Mr. Harris?
Quickly, Your Honor, I would just refer to our written response originally to the motion back on October 18th, 2024, wherein we point out that a bunch of things. First, that the idea that there's this ordinance that directs that the comptroller investigate this matter to the exclusion of anyone else, including the appointing authority, is not legally sound. There's no legal support for it. In fact, we cited a case where a similar argument was made, and the Court of Appeals held that the civil service rule that was at issue in that case, Wilson versus Civil Service Commission of St. Louis, the civil service rule providing that the director of personnel shall conduct an investigation into certain rule violations did not provide that the director is the only official who can conduct such an investigation. In other words, even if there were some suggestion that the comptroller is the party that would, investigate what happened here, there's no, neither the charter nor the ordinance nor any other rule of law indicates that the comptroller is the only person who could look into this. And the notion that the appointing authority cannot review the conduct of the person who is appointed, in this case the director of personnel, would seem to fly in the face of all sorts of norms and the way that governance is typically executed. So the fact that the appointing authority is the one who, the appointing authority's designee is the one who received the report and looked into the matter. There's nothing in the law that suggests that that was improper.
All right. Next one that I have on the list is motion to disqualify the city councilor. Now, Mr. Norwood, you have during the hearing made a lot of argument about that. Anytime Mr. Garvin, there was references to him, and in fact we had him come up and make a statement on the record here. Briefly, you want to just, anything you want to add to what you've already said about that?
Absolutely, and that to me, quite frankly, is the most troubling aspect of this whole process, right? They argue, perhaps correctly, that the fiduciary obligations owed by Mr. Garvin, owed by the city councilor, are to the city and the mayor. Their ethical obligations, according to them, are to the city and the mayor. So what we have is a situation where, and this is borne out by the eloquent recitation by by Mr. Garvin about the fact that he got pulled off the bench in the 9th inning to close this thing out. The game had been going on for 8 innings in the form of the city councilor being actively involved in the investigation, the city councilor advising that those subordinates, the mayor, we don't know who because we'd like to talk to her at least in terms of who she communicated with as opposed to what the communications actually were. But she was involved. And the cases made clear that, and the cases that we've cited deal with the issue of disqualification of an entire office, the public defender's office. And the Supreme Court made clear in its rulings that you have to set up safeguards on the front end to make sure that there is no prejudice. And in fact, the cases go so far as to say there is a presumption of prejudice. And why? It makes all the sense in the world. Because of the fact that a party should not be able to have their representative in the room deliberating and guiding this body in terms of what malfeasance is, what determination should be made, what discipline should be meted out, if any, when it is their boss who has made the decision already that there is malfeasance justifying proceeding down this path. And so that, to me, is a fundamental problem with the whole process. It has nothing to do with Mr. Garvin. It has nothing to do with the commission necessarily. It has to do with fundamental fairness. No one on this panel would want a situation where the lawyers for the other side is talking to the judge about the case on a regular basis. It doesn't get more fundamental than that. And for that reason, I mean, the simple solution, and this is what we suggested early on before we got to this point, retain another lawyer, an independent lawyer, to provide independent advice to this commission so it's not tainted by the mixed dual loyalties that the city councilor has with respect to serving this mayor and serving this commission and serving fundamental justice and fairness for my client.
Okay, any brief response, Mr. Harris?
Your Honor, we would just rest on, again, on the response that we made in writing to the motion that was originally filed, and we would also point the commission to the response that was submitted in the actual court case that addresses this issue as well, and we believe it nicely puts the issue to bed.
And you're talking about the one in front of Judge Moriarty.
Correct.
All right, then the next one I have is a motion to disqualify the commission and alternative motion to disqualify Commissioner Barney.
Yes, if I might briefly.
Go ahead.
And we have evidence in the record about that. I mean, the troubling aspect is the fact, again, the taint arising from this representation by the city councilor that has an ethical obligation to represent the city. That taint, intentional, unintentional, implicit, or explicit, doesn't matter. That taint we feel has tainted the tribunal in a way that perhaps not even the tribunal might realize because of the fact that they're being advised by the prosecutor, in this case, the mayor. As to Mr. Barney, with all due respect to Commissioner Barney, Chairman Barney, what happened, why it happened, I don't know, but what happened in that public meeting that I watched with my own eyes, and in fact, during the session, I got a call, and it was insane, the fact that we were talking about a disciplinary matter involving the top person in the Department of Personnel, when every other person has that protection and right to privacy. Before public notice was sent out, before the matter was set for hearing, we all agree that once it's a public hearing, once it's public, all bets are off. But it wasn't public. And in fact, we've heard testimony from Director Jenkins Gray, and hedging her bets, not knowing what her future holds with the city, she would apply to another fairly lucrative position, which was lost. And it was right around the same time of this public announcement. So we feel that that's problematic enough to cause the commission to say, why would I want to proceed down this road with that sort of issue hanging over, that cloud? It's a cloud. Remove that cloud by simply saying, okay, fine, we'll disqualify ourselves. And so that we have, and then the fact that, as you indicated, Your Honor, on the first day, they're deciding whether or not to disqualify themselves. That, to me, is a conflict. How do I decide whether or not I have a conflict that precludes me from representing the client? I mean, those are sort of the things that make it problematic, and that's the basis for the motion.
Any brief response?
I mean, I think the suggestion is akin to what happens in court cases where, the lawyers make some allegation that the judge should be disqualified for a conflict, and a disinterested judge can consider that request and consider the facts and circumstances and any evidence in that regard and make a reasoned decision that there is no conflict and that there is no reason to disqualify themselves from the matter. And I think that that's really the case here. There's no evidence to indicate that there's a conflict or that there's any reason for the chair of the commission to disqualify himself, that there's no evidence that he's biased or in any way conflicted from listening objectively to the evidence in this case and rendering a recommendation.
Okay. The next one that I have, and just to be clear, I think so far, all three of those were included in the ones that we announced at the beginning of the hearing. The commissioners had considered the written submissions prior to the hearing, and the motions were denied. Okay, so next is the motion to quash the city's document subpoena. Now, is that moot now? That's the personnel director's motion to quash a city subpoena for documents from the defense, right? Or the personnel director, right?
And we produced, in response to that, the single item we had, and so it is, in our view, a moot point.
And does the city agree to that? That motion is moot?
Yeah, I believe that motion is moot.
Okay. Next is number 5, the motion to exclude testimony related to personal family matters. Now, I think at the pre-hearing, what I announced was that motion would be taken with the case and would have to be renewed at the time of the any evidence about family matters would come up. And then, of course, Mr. Norwood, you did object when there were questions about it. I initially sustained the objection, made a ruling that Ms. Gray did not have to disclose what was in the contents of the items that she retrieved from her car. That was when she was being questioned about the trip to Jefferson City, and when you got to that point, I made that ruling. And then later, there were further questions about it, I think maybe the next day, and I did not, as I recall, I did not allow any questions. In other words, the original ruling regarding what was the contents of the matters retrieved from the car, the papers, I continued with the ruling on that. I did not permit Mr. Harris to ask. I think he tried. You objected. I reaffirmed the sustaining the objection, correct?
Yes.
But then Mr. Harris had additional questions about other things that took place during the trip to Jefferson City, and I overruled your objections to those things on the basis that they were not family matters, all right? In other words, just because the testimony from at least one of the witnesses, I believe it was Dr. Bird, was seeing Reverend Gray, the husband of the personnel director, that in and of itself did not make it a family matter. And then there were other questions later of other witnesses about what conversations were had with the personnel director by Ms. Lambert. And I can't recall all the evidence, but at that point, then I overruled your additional objections and allowed the questions, and the answers were in about further things relating to the family relationship, what was going on between, if anything, between the director. Was there, in fact, any confrontation with her husband or not? Because I think that's something, there was a dispute in the evidence about whether or not that even occurred, as well as I understood it, the director disputed the reason that these other witnesses were saying she went to Jefferson City. So she testified to that effect, but they were able to testify as to what they said, and your objections were overruled. Am I correct on all that?
Yes, you are correct, and of course, that horse is out of that barn, and therefore,
Moot at this time.
at this time, right?
Okay. The rulings were made, they're in the record, and they went both ways. Mr. Harris, is there anything I said that you think was inaccurate regarding the way that was handled?
Nothing that comes to mind.
Okay.
I think you were fairly accurate.
Okay, so, and do you agree that, for practical purposes, that motion is now moot?
Yes.
Okay. The next motion I had on the list that we discussed was a motion, again, by the personnel director to strike the city's motion to quash as untimely, and I believe at the time I announced that that was moot. I don't recall either one of you at that time contending, no, we need to take that up. Do you both agree with that?
Yes, Your Honor, on our side.
Yeah, my notes do indicate that the court, that you did say that that was moot because the subpoena was not issued. That's right, and we agreed that was moot.
Right. Okay, next one I have is the motion to strike, again, this is by the personnel director, to strike the city's motion to quash subpoenas issued as untimely. Now, I believe the motion to quash as untimely, the motion it's referring to, I believe, that's the city's motion to quash the subpoenas of the mayor, the comptroller, the city councilor, the airport director. Is that correct? Mr. Norwood, it's your motion. Is that the motion that you were directing your motion to quash at?
Yes, that the position taken in conjunction with that motion is that the motion to quash by the appointing authority was filed one business day before the setting of the hearing on January the 6th. So really, the issue raised in that motion was the timeliness or the untimeliness of the motion, given what we understood to be rules that would be in place at some point once the hearing began.
Okay, I'm sorry. I believe that at the time I announced we would hear that motion. The motions, both motions, the motion to quash the subpoenas and the motion to strike the motion to quash the subpoenas.
And
And
if
we
I-
would hear that. I believe I announced that at that time. Is that what you recall or not?
Well, what I understood that this one was denied. I could be mistaken about that, but let me add to the record on this point, which is the fact that we served a subpoena that we sought to have the former chair testify. And we submitted that through the process as we did with the other subpoenas, and that subpoena was denied.
Okay, a subpoena to have the former chair of the commission,
Yes.
that's Mr. Kerry Debo.
Perry,
Not sure
Perry
how you
Dibo.
pronounce it. Your motion, you wanted to subpoena him.
We made a request through the channels to have that subpoena issued, which was the process for the issuance of all the subpoenas. We all sent emails to the commission email, and in response, we got back either confirmation or copies of subpoenas that were in play. And then for that particular subpoena, it was denied. I believe it was based on untimeliness. And so, again, we
Denied by whom?
by, I assume it was Dr. Berg who denied it.
All right. It was not issued.
It was not issued, and one of the fundamental issues we have and evidence we'd like to present in our case relates to these acknowledged ex parte communications between the chief of staff, Mr. Jared Boyd, and the former chair, and those phone logs that the former commissioner produced to us and to I believe Mr. Garvin, shows 22 phone calls in a 45-day period and 18 within a 30-day period. And so, to me, that is key evidence on the question of improper activities by the mayor as it relates to, and her staff, as it relates to communications. We submit improper ex parte communications with the commission.
And improper because why?
Well, I think if I was litigating a case before you and the other side came up with a phone log showing that I've communicated with you 22 times, I think that would raise at least an inference of some troubling communications, right? There is no need for me to be communicating with you 22 times over a 45-day period to discuss a case that's pending before your honor, right? There are rules of ethics that would even allow you to do that. You wouldn't do it. We know you wouldn't do it because it's improper. And so it shouldn't be proper in the context of this proceeding just because it's an administrative tribunal. And in fact, the case law is pretty clear as well that those kind of communications are proper. They're in violation of the civil service rules. They're in violation of, well, what did we hear from Ms. Baker? Common sense, right? I mean, you don't have that sort of activity.
You
And
say
that's-
it raises the inference of what? I didn't catch.
it raises an inference of improper influence. It raises an inference of improper communications regarding a pending matter. It is unethical and is improper. Plain and simple.
Okay, now that, you're talking about the motion to subpoena the former chair.
Yes.
Is that what your
No.
motion to strike was about?
This doesn't relate to that. The parallel is the fact that they were issued a subpoena on a day's notice, and our subpoena was denied. And ours, I think, was at least a week.
In other words, the one that was denied is this one that you're talking about?
Yes, exactly.
And it was denied because you issued it on only a day's notice, or what?
My recollection of the communication was that the request wasn't in compliance with these rules. And I don't know if it got any more detailed than that. I assumed it was talking about the timeliness of the subpoena or request, because I think the rules, and I mix up the old rules with the new rules, that the subpoena request had to be made within a certain number of days in advance of the hearing.
All right, is this communication about its denial? Was that something in writing? We don't, the commissioners, I don't believe, have that in any of the materials, do we?
Well, it came from, my request went to the commission email box, wherever that goes, and the response came from,
Well, the two commissioners, they don't get all emails directed to the commission. In other words, that go to the commission staff.
yeah, exactly.
Somehow, whatever the
Right.
setup is, handle that. That's
So,
the
right, the
two
staff.
commissioners have no notice of that. That's,
Right, I understand that. I mean, I understand it goes in a box and they decide what to deliver, communicate to the commissioners. And in this case, I assume before they denied it, they would have communicated with you all, but if you all are not aware of that, that's fine, but that's what we have. And I can dig out that email. I don't have what I need to dig it out here, but I'll have my assistant dig it out and we can make it part of the record.
All right. All right, that's still with regard to the motion to quash the subpoena of the former director. Mr. Harris, did you have anything to add with regard to that?
Just that I don't believe that that the appointing authority requested a subpoena a day, before the hearing began and it was issued. Our records don't indicate that. Also,
In other words, your motion to quash the subpoenas, you're talking about, you don't think your motion to quash the subpoenas or any other motion was filed less than what?
I thought he just said that we requested a subpoena outside the time in which it's allowed, and it was issued. And
Okay,
and we
all
didn't
right,
do that.
all right. Is that what you said, Mr. Norwood? If you did, is it? Mr. Flewellen is telling me that's what he heard. Mr. Norwood, is that what you said? If you did, please clarify.
What we
you-
have in our motion, for the record, is we say specifically that the motion to quash was filed one business day before the hearing set for January 3rd, is when it
The
was filed.
what motion to quash? The
Motion
motion,
to quash that was filed by the appointing authority, directed to the subpoenas for Mayor Jones, Comptroller Green, Nancy Cross, Sheena Hamilton, Rhonda Hannah Newberger, and Comptroller Jace Flood. So that was the motion to quash that was filed, and we took the position that under the rules, it was untimely.
okay, but you're saying that motion by the city was filed when?
According to our records, that motion was filed on January the 3rd, 2025, which I believe was a Friday, before the snowed out January 6th scheduled hearing day.
All right, and you're saying that that was untimely because it should have been filed when?
Under the rules, as we read them, I thought it was at least 5 days before.
5 days before a hearing.
Before the scheduled hearing day.
Now, Mr. Harris, that's what he was talking about, so what is your
So it's my
understanding?
It's my understanding that the motion to quash that we filed, that their motion to strike relates to, was to quash subpoenas that were directed, and you may have said this, I apologize. They were subpoenas, Dukas Tecum, that were directed at the mayor's office, the airport, and the comptroller. And we did file a motion to quash that subpoena. And I would just point to the rule, the rules that are in place for this matter. It's section 4 on subpoenas, section
Four of
4K.
what?
Of the evidentiary hearing rules,
Okay,
the Civil Service Commission evidentiary process.
okay.
4K says a motion to quash a subpoena ducis tecum must be received by the commission no later than 5 working days prior to the scheduled hearing date. This rule does not apply to proceedings conducted pursuant to Article 18, Section 9Q of the city charter.
And is that what we're under?
Yes,
So, does not apply.
correct.
Well, it applied at the time the motion was filed. It didn't apply once on the 7th of January, after we filed the motion, that there was the change to the rules.
Was there a change in the rules?
Yes, that language about unless it is under section Article 18, 9Q. That was added to the new rule, I understand.
All right. I think we're going to get to the motion on the rules themselves here in a minute, but we're still on what I have as 7. So am I clear that the motion to strike opposing counsel's motion to quash subpoenas was the city's motion to quash the subpoenas ducis tecum? Is that what you think this motion applies to, Mr. Norwood?
Which motion are we talking about, the motion?
Mr. Harris said that he believed that your motion to strike opposing counsel's motion to quash subpoenas, he's saying he thinks that that was directed at the city's motion to quash the subpoenas ducis tecum.
That was a separate motion, I believe, and I think that's the motion we had just talked about, right?
Well, we just talked about it, yeah.
So we got two
But-
motions of quash. We
But
go-
you're saying, okay.
There was a motion to strike the motion to quash as untimely. And then there was a separate motion to quash the subpoenas that they served on the director, that issue is now moot, I believe. Yeah, it was a combination motion to quash the city's document subpoena and opposition to the city's motion to quash. Opposition to the motion to quash the testimonial subpoenas of the mayor and the various other folks, including the comptroller and city councilor, Sheena Hamilton.
All right.
And if he's seeking to strike our motion to quash the subpoenas ad testificandum, the subpoenas requesting testimony, there's no rule about when that kind of a motion can be filed in the matter.
Well, under the old rule, I thought there was a 5-day requirement for ad testificandum subpoenas, and I thought a 10-day requirement, at least in the old rule, on document production.
No, I think that 5-day rule is just for document subpoenas.
Well, that was the old rule. I have to pull out the new rules to see. And I think there may have been a carve out for this particular proceeding in those new rules.
I do not believe, my notes do not reflect that we made a ruling on the motion to strike opposing counsel's motion to quash subpoenas. My notes say that we said we would hear that.
Right.
And that's the one where my notes say that's the one that you said was moot because the subpoena was not issued. Is that?
Well, okay, yes. Now, here, I'm sorry, I'm sorry, you're correct. The motion to strike the city's motion to quash, we said was moot. Correct. The motion to strike opposing counsel's motion to quash the subpoenas issued as untimely. That was your motion, right? No. I'm sorry. I'm looking at one motion filed by Mr. Norwood that's is headed, motion to strike opposing counsel's motion to quash subpoenas issued as untimely. So that's the one covered by number 7 that we said we would hear. We said we would motion to strike the city's motion to quash
Well, I guess.
was moot.
Well, the short circuit that, what he's suggesting is that the new rule would not prohibit the finding of that motion. Is that right, counsel?
Correct.
So if that's the case, then, again, this was filed in accordance with the rules on the books at the time we filed the motion, which was the 6th, well, actually, it was, on the 6th of January. So that motion is moot in light of the new rules, so we can maybe move forward to the next one.
Okay, you're agreeing that number 7 is moot?
Number 7, the motion to strike opposing counsel's motion to quash the subpoenas as untimely is moot in light of the rule change.
And you agree with that too, Mr. Harris?
Yes, Your Honor.
All right. All right, then we'll move to the one I have next on the list is, let's see, I'm sorry. The next thing I have on the list is the motion to preclude the use of a hearing officer. It wasn't directed against me personally, as I understand it. It was any hearing officer to run this hearing. Is that correct?
Well, at the time we filed it, we didn't know who the hearing officer was. That's correct.
But I mean, in other words, it wasn't based on any conflict of interest that you're alleging that I have.
No.
It's that you're alleging the rules don't permit a hearing officer, is what you're saying.
The charter.
City
doesn't.
charter, you're saying city charter governs, and the city charter does not say anything about a hearing officer, right?
One way or the other.
That-
What
right.
it does say, though, is that the hearing shall be conducted by the commission, and in our view of the world, that means a 3-member commission and not a 2-member commission.
Okay, so I believe that, do you have anything to add other than that, do you think the charter provisions govern and that's because they don't allow a hearing officer's not permitted?
Well, I'll read into the record the language from Article 18.9Q. It says, "The public hearing shall be conducted by the Civil Service Commission."
Okay, and that's Article 18,
Roman 18, 9, small q.
Section 9, small q.
Yes, and we even cited in the motion 2 cases involving the Board of Police Commissioners. One in the Eastern District, one in the Western District, where in their provision they specifically said that board trials would be held before the Board of Police Commissioners. And in those cases, they used hearing officers, and in the one case, I believe it was the one involving the St. Louis City Board of Police Commissioners, there are some factual variances. I think in that case, it was a situation where there was a hearing officer. The hearing officer conducted the hearing and made available all of the evidence, all of the transcripts, and that sort of thing. And the court in the Eastern District and the Western District, they both made clear that no, if the language says shall means shall, and that's our position in this case. And so it has nothing to do with Your Honor or any other judge. It's just a question of what does that language of the charter mean when it says the public hearing shall be conducted by the Civil Service Commission and is silent about the use of a hearing officer.
Okay. And that would address both points, no hearing officer, and you raised it, I believe, in number 13 was the last one on this list that I have notes on, the motion to preclude the hearing from occurring in the absence of a three-member commission. You just addressed that.
Yes.
All right. And my notes say that we said we would hear that, that it would be taken and heard, decided by the commissioners based on how it was submitted in writing. All right. Mr. Harris, anything you want to add?
Yeah, I would just note that, the charter does require the hearing to be conducted by the commission, and the commissioners are here to receive evidence, review evidence, listen to witnesses, make their recommendation based on the evidence that was presented. So there's nothing improper about how this proceeding has been conducted in that regard, and this is precisely what the charter was calling for. And again, the charter is silent as to whether a hearing officer would participate as well, but that doesn't mean that the hearing officer is improper. The hearing officer is here to help help maintain a smooth hearing, and hearing officers are often used in matters that are presented to the commission, such as this one. And so there's nothing improper about the use of a hearing officer in this matter. Also, the charter or the rules, all they say about the number of commissioners is that you need a quorum, which is 2, and we have that in this case, and so there's nothing improper about the procedure.
Is it in the charter itself, or does the charter silent as to 2 members of the charter?
I can't remember if it's the charter or the civil service rules, but there is a provision that quorum is going to be 2.
All right.
Well, let me say this. He's referring to a rule. The charter says, Article 18, Section 6A, says the Civil Service Commission shall consist of 3 members. That's what the charter says, and you obviously, I think council would agree, you can't adopt a rule that conflicts with the express language of the charter. He's saying that there is a quorum. Well, you got to have 3 members in order to get the quorum. We don't have a quorum of 2 when you only have 2, and that was our issue there. And just quickly, for the record, the 2 cases I cited, same arguments they were raised in this State X-Rail McGull versus St. Louis Board of Police Commissioners, 178, Southwest 3rd, 719, Moab, Eastern District, 2005. They raised the same arguments. It's convenience. We don't have time to be sitting around. That's why we pay these hearing officers. And they say, no, that's what you signed up for. That's what you got to do. And that's why, to this day, every board trial over there at the police department, and I represented internal affairs for 7 years, and I argued on behalf of the internal affairs division, a lot of those board trials before the Board of Police Commissioners. No hearing officer was utilized in any way, shape, or form because of this case.
All right. Anything else, Mr. Harris?
I mean, I would just say that, the notion that because the charter says that the commission shall consist of 3 members does not mean that the commission cannot conduct business when they have 2 out of the 3, which is a quorum. It'd be like suggesting that, because the Board of Aldermen shall consist of 14 members, It doesn't mean that if one or two of those seats are vacant, that the board can't conduct business. I think that's essentially the same here.
And there's no reason why we couldn't wait until we have a third commissioner in the seat.
Okay.
And we would, all of this would be moot if that were the case.
Okay, next motion on the list I have is the motion to exclude evidence of any violation not specifically contained in the notice of the hearing. And I believe I announced at the outset that we'd take that with the case, that would be something where if there was evidence attempted to be introduced about such a violation, that there'd have to be an objection and a ruling at that time. Either one of you think that that's not how that motion was handled?
That's how it was announced, and then
Okay,
when we
did we have anything that came up regarding the motion?
Absolutely.
Okay,
There was testimony about the Fusion Lounge receipts. There was testimony about this parking policy violation. That all came in over our objection.
And the commission may recall that discussion, that issue came up, and we pointed out that the pre-termination letter, the pre-termination notice indicated that the director's prior work history would be taken into account, and that's part of that was part of the reasoning for allowing that testimony in. I mean, I think that was the basis for allowing it in.
all right. And what was, you said the Fusion Lounge receipts, what's the other thing you said that was brought in?
There was testimony about a trip to Harvard. I think the Fusion Lounge thing was a Harvard receipt as well.
That was a part of that, I believe.
Right, where she parked and submitted reimbursement for the parking at Lambert to whoever handles those submissions. And then it was pointed out to her that the city didn't pay for parking, was what she testified to. And based on that, she reimbursed them, and that was it. That did come in. And as we stated on the record, the Swartz versus City of St. Louis case, 274 Southwest 3rd 509, says that an employee must receive sufficiently detailed notice. When you say we're going to consider everything under the sun, I don't think Swartz, the Missouri Court of Appeals, or anyone else would suggest that that is sufficiently detailed notice. And why do you have it? It says it so that he or she can protect him or herself from an unfair disciplinary proceeding. It is unfair to the lawyers to walk up in a proceeding and all of a sudden we got stuff coming out of the woodwork that wasn't specified in the charge. That's why you frame it up. If it was so important that they're going to introduce it here, it should have been so important that they include it specifically in the notice so that my client could properly prepare and so that counsel could properly prepare to defend. And at the end of the day, they haven't even charged it. But they throw it in here just to, I don't know, I guess you have to ask Mr. Harris why it even came up to begin with, including the Fusion Lounge thing.
All right. Nothing else on that
I
number?
think we've made our argument on it.
Okay. Now, number 10 on the list I have is the motion to preclude adoption of new modified rules. I believe we did hear that on that first day.
Yes.
And after hearing it, I believe, did we announce a ruling?
Yes.
Which was denied, right?
Yes.
Correct.
Okay. Number 11, and I have for 11, 12, and 13 we've already discussed. That was with our discussion about number 8. I have on 11 and 12, my notes say that we announced that they would be ruled on as submitted in writing prior to the hearing, and the commissioners ruled that those were denied. Correct?
Which one were those?
This is, okay, 11 was a motion for a continuance based on the allegation of a defective notice and new evidence and non-response to subpoenas.
Yes.
And the other one was a motion for a continuance to allow a judicial ruling. In other words, that the commission should rule on the motions, then recess, let you file some type of a pleading to open a case in circuit court in which you would ask for review of the commission's ruling on those motions, and only after the court had ruled could the commission then proceed with the hearing. Is that correct?
Well, actually, it was an invitation for the commission to invite that scrutiny so that we know what we're doing. The underlying motion itself was based on the fact that we got 400, 500 pages of documents from the city on the Sunday before the scheduled Monday hearing. There were other documents we didn't get. For instance, we asked for certain cell phone records. We didn't get those. And we believe other items that they objected to we didn't get as well, such as the policies and procedures relating to how these whistleblower complaints are handled. So there was a whole litany of documents that we got at the last minute, and we didn't have time with the snow and the hearing set to press on these other documents we need to effectively try the case. And so that is the basis for the continuance, to allow us to hash out the question of what other documents do we have, why don't we have them, what's going on. I think he filed some affidavits saying, well, the main issue is, and this was strange too, we served a subpoena on the custodian of record. They say, well, there is no custodian of record. So then we broke it up and we served each department, and each department said, well, we're not the custodian of record. I mean, it's a shell game with respect to who has the records. Every organization in the free world has a custodian of records for this very purpose, but here we're caught up in this quagmire of suggesting that, well, we don't have a custodian. And that, as the court knows, is laughable.
Well, the rules say, if agreed upon, parties may exchange documents prior to the hearing date. And so we did provide documents, about 440 pages. And, you know, we didn't get a bunch of documents from the other side. In fact, there were a bunch of exhibits that were shown to us from them during the hearing. And that's because the director herself, I'm sure, has access to tons of documents over there in the Department of Personnel. And if there were documents that, you know, supports whatever their claim is as to their defense, I would imagine that we would be seeing those documents throughout the course of the proceeding, and we haven't seen those.
All right. Mr. Norwood, I'm not quite clear. What documents, your motion, I'm sorry, you tried to subpoena the city's custodian of records, and a subpoena was issued by the commission for the city custodian of records, correct?
Yes, ultimately. Well, let me back up.
Ultimately,
Ultimately, in that, in October, as I mentioned on the record, we made a motion with the commission for the issuance of investigatory subpoenas for pretty much the same litany of documents we were asking for. And we never got a ruling on that motion. And then, as this hearing was nearing, we served a request for pretty much the same documents on the city, and we got 400 pages of documents. And so it was a litany of documents off the top of my head, and we're going to dig out the document. We asked them for the policies and procedures, or we asked them for documents relating to actual discipline of folks for violation of the vehicle use policy. We never got any of that. I think they may have objected to it. We asked for documents related to the investigation. I think we got some of those documents. I don't know if we got all of the interview notes or anything like that. We asked for documents related to communications with the city councilor, the number of communications as opposed to the substance of those communications. We asked for communications between various individuals, including Mr. Boyd, with various commissioners. We got some of those. Well, no, I don't think we got much. We got some. We have some text messaging between Mr. Boyd and the former commissioner. I think there may have been one or two emails. I think Commissioner Llewellyn had an email in the mix that we got that we talked about. We'll talk about some more. I think there was one or two emails from the Chair Barney, but we didn't get that. And we have all these phone records we asked for. We never got that. So, and there's a litany of other stuff. Just bear with us while I dig out the list. And so that was the basis for the continuance, to allow us to go through the list so that the commission can make a ruling on what's in and what's out, so that we could have a fair trial based on evidence, instead of having a trial where effectively we got to do discovery because we didn't have the documents and we didn't have access to the witnesses and we couldn't depose them under the rules.
All right. All right, that I have is the ones that I believe we announced before the hearing started. Then we still have a number of other motions.
Yeah, and I don't know, I mean, I have a list. I think we, as part of the motions we filed a copy of the motion.
Let me just say, I have an entire binder. I have several binders, actually. One binder is from you. In fact, two of them, I believe, are from you. One is your binder of exhibits.
Right.
Okay.
This would have been submitted with those list of motions, which incorporated the subpoena request. And the subpoena, again, we asked for a list of some 29 categories of documents. And I don't want to go through, in the interest of time, through the complete list, but it includes those documents identified. We asked for documents.
All right, well, when you say we asked for, what I'm trying to cover here are motions that were filed.
Right, and the motion to continue to allow us to explore the documents we requested pursuant to the subpoena that was issued, documents we hadn't received, documents to this day we have not received, even though we're in the latter stages of this proceeding.
All right, well, the problem, Mr. Norwood, is what we're trying to make a clear record here. Now, let me just back you up here. We went through the motions we discussed the first day. I have a binder that I received, I believe it was from you, motions TOC.
Yes.
Right?
Yes.
TOC meaning? It's not the...
Table of contents.
Table of contents? Okay. Now, those are motions that I don't think, some of them I think you've mentioned as you discussed some of these other things.
Yeah, I think we
Some of them
agreed.
have never been mentioned, I think. I'm not clear when these motions were filed, but let's just go through this.
I think those are the same motions that we've systematically covered. That binder and the table
Well,
of contents.
Okay, but they're not all in there, I don't think. Motion to disqualify the mayor's office, okay, that was number one. Disqualify the city councilor. The director's motion regarding the issuance of an investigative subpoena.
Yeah, and that was the one.
Now, I don't see that on the list of what we just talked about.
That was the motion that's been pending since October. And because the hearing started scheduled to start on the 6th, actually started on the 7th, that motion became moot because we never got a ruling on the investigatory subpoena, which again includes the same items that we've requested in the actual subpoena that was issued and served on the appointing authority.
Okay, are you saying that you believe that your motion, which I just referred to, it's in tab 3 of the binder that I just referred to, where it's Director Jenkins Gray's motion regarding the issuance of investigative subpoena. Are you saying that is moot?
It's moot because it was never ruled on, the hearing started, and we never got the investigatory subpoena.
All right. All right. Anything you want to say with regard to that, Mr. Harris?
With regard to that, I think Mr. Norwood mentioned it, but there was in fact a subpoena that was issued to the city for the same documents and things that were requested there in the subpoena that are the subject of that motion. So that's another reason it's moot.
So there was an investigative subpoena issued?
No. The
What
investigatory.
are you referring to, Mr. Norwood?
There-
Mr. Harris?
Well, there was a subpoena ducis tecum that ultimately did get issued to the city, and it was for the same records, categories of records that are being requested in that investigative subpoena that is the subject of that motion.
And what happened after that was issued?
I would imagine, I believe that
Mr. Norwood referred to getting pages of documents from the city.
right, yeah.
All right, now, is that reference to this particular document, or is it something else?
So we provided documents to the director, as I said, about 440 pages. Some of them, I believe, were in response to some of the categories of documents that were requested in the subpoena. And in the various motions to quash that were filed, I believe we objected to some of those categories as well. So yeah, we have provided 440 pages of documents back on January the 5th. With respect to the notion that a continuance is needed, I mean, we're here now on February the 4th, so they've had time to absorb those documents throughout the course of this proceeding.
All right.
Yeah, it's not the documents we received, it's the documents we haven't received is the issue.
So they requested personnel, they requested, disciplinary records related to other employees who are not the subject of this matter, and the rules don't allow for that. And they requested other kinds of records that we also objected to.
They objected to some, not all of the requests, number one, and the ones they didn't object to, we didn't receive the documents.
All right.
I don't know if that's the case.
All right, now, going back to this, I think that covers that particular motion, right?
Yes.
Which I believe is moot, from what you both said.
Yes.
Number 4 on your folder simply says city's response, so it's not a motion.
Yeah.
It's
just a
something
briefing
you
line.
included to show how the city answered your request.
Yes.
Okay. Number 5 is this motion for continuance, which we've already talked about, it was number 11.
Right,
We've already talked about that.
right.
Number 6 on the list is the motion to quash subpoenas issued to Mayor Jones, et cetera. Now, that is the city's motion,
Yes.
and we have not ruled on that yet, I believe. Is that correct?
Well, what happened is there was a preliminary ruling and then the directive to
There
submit
was
the
a preliminary
briefings.
ruling by the commission at the hearing?
On the last hearing, initially, it was intimated that the mayor's testimony wouldn't be allowed, and then after the commission met with Your Honor, I believe, is when the directive came out that we would submit what we submitted yesterday
Right.
on those issues.
So it
And
wasn't
that-
ruled on, it was
It
held
was
in abeyance
tabled.
while we got further
Yes.
information?
Yes.
Is that your understanding, Mr. Norwood?
Yes.
I mean, yeah, Mr. Harris?
Let me just try to, let me make sure I'm on the same page with which motion we're.
We're on, this is the city's motion to quash the subpoenas issued to Mayor Jones, Comptroller, Executive Director of Operation, and the two members, Mr. Norwood indicated he was not pursuing them. Is
Oh,
that
okay.
correct, Mr. Norwood? Nancy Cross and Jason Fletcher?
Yes.
You dropped?
Yes.
But it's still, you're seeking to subpoena Mayor Jones, Comptroller Darlene Green, City Councilor Ms. Hamilton, Airport Director Ms. Ham Nieberge.
We
Now-
have subpoenaed them, and then they moved to quash the subpoena.
Right, that has not been ruled on, that's
Yes.
pending.
Yes.
Right, except as to the mayor, that was, our motion was sustained at the last hearing, but then, there we started talking about this business of offers of proof, which has precipitated the filings yesterday.
Well, more precisely, as the commission took up their motion to exclude evidence of political interference and our arguments that a number of the witnesses, the top of which would be the mayor, are relevant to that issue. And so there hasn't been a ruling yet on the political retaliation, and that's what the supplemental briefing was about.
Okay, and we'll get to that. All right. So, that one is still pending. Number 7, motion to quash subpoena. This is the appointing authority's motion again. The appointing authority made a motion to quash the subpoena requested by the director to the keeper custodian of records. Now, that, as I understand it, that subpoena itself was issued, and the motion to quash was never ruled on. Is that correct?
I think that you may be referring to, that sounds like the one where the subpoena was not issued, and so we said that one was moved.
The
that's
city's
what we've already-
subpoena?
Here, let me just read it.
Okay.
Says Jenkins Gray has requested a subpoena for documents be issued to the keeper custodian of records, City of St. Louis. At the time you filed this motion, which it looks like was back in December, 27th of December, you said the commission thus far has not issued a subpoena. Okay, and then you go on to say you're seeking to quash it. And if it is issued, you're seeking to quash it. And also you argue that it's void because there is no custodian of records title in the city, correct?
Right, and so I think that so that's the one where then there was a subpoena that was ultimately issued to the city. And so that, there's no reason for us to proceed on that motion any longer.
Okay. Moot because subpoena was issued. Is that what you're saying?
Yes.
And you agree with that?
Well, yeah, you refreshed my record. It was a preemptive filing
This was his motion
Right.
to quash the subpoena.
that hadn't formally been
At the
issued.
time, it wasn't ruled on, it was, the subpoena in the meantime was issued, and he's saying now it's moot.
Right, right.
All right. Next on the list is motion to strike. This is by the director moving to strike the city's motion to quash issued subpoenas. Now.
And we discussed that one.
That's the same motion about the subpoenas to the mayor and comptroller and so forth, right?
Yes, yes.
So that would be included in arguments regarding the motion to quash those matters,
Yes.
okay?
And I did find that email from, it says it's from the commission regarding our request for the issuance of the subpoena for the former chair of the commission. And so I could read that into the record, or I could email it to the commission, which was from the commission.
Could you give it to the staff and then they could make a copy of it?
It's on my phone.
It's on
but
your
I could-
phone,
I could,
okay.
If you forward it to me, I can work with them.
okay, so I'll forward it, and we'll forward it, and we'll print it for the record, but I would like to.
Copy for everybody, what, Mr.
Oh,
Harris,
copies for
Mr. Norwood,
everybody.
and
Okay, okay.
the commissioners,
And-
okay?
And for the record, though, and I won't read it all, but we had requested the subpoena, and the response from the commission says the Civil Service Commission has obtained your request for the issuance of additional 3 subpoenas based on the evidentiary hearing rules adopted by the Civil Service Commission. Your request is denied. Now, the email is dated, looks like 1/15, so it would have been, I guess, under the current rules. But it said it is denied, and it cites certain provisions of the rules, which say all parties shall be entitled to subpoena witnesses at testificandum, testify at the hearing, as well as subpoena documents. Parties shall be limited to 10 subpoenas, both at testificandum and ducis tecum, which I had never understood that to be the rule, but in any event, that's the explanation provided by the commission. Absent extraordinary circumstances presented to and approved by the commission chair, says blank subpoena shall not be issued. Well, we weren't asking for blank subpoenas, we were asking for signed subpoenas. A request for the issuance of subpoena at testificandum must be received by the commission no later than 5 working days prior to the hearing date. Untimely requests for issuance of subpoena shall be denied. And that was from the commission.
Well, you said
dated-
from the commission.
Well, the email.
The email was from whom?
It says respectfully, Civil Service Commission. And it is dated.
Not signed by any individual?
No, it's an email. It's not signed by anybody. And it is dated January 15, 2025. The request was made before, but the response came in on January 15, 2025.
Okay. All right, then. Next, I have on the list, motion, I don't think we have talked about motion to disqualify Civil Service Commission, in the sense that you talked about your motion to preclude the hearing from occurring in the absence of a 3-member commission. But this one, I believe, is different because you have in it motion to disqualify the commission because it's a 2-member commission, and she should get a fair and impartial, and the arguments are included in your written thing about the city councilor's office having been involved in communications and so forth.
Well, this was.
Right? So this you've partially discussed, but in the alternative, I don't recall discussing earlier, maybe we did, your alternative motion to disqualify Commissioner Barney. correct?
Yeah, but this one, I think, well, yeah.
And I think Mr. Barney did address that back at some point when that came up. Didn't you make a statement about what you had done or not? Do you recall?
Oh, I
that?
don't think I
You don't think you
actually did.
have?
I'd be
Okay.
happy to. But
I'm just looking, the only mention it looks like of Chairman Barney is what you have talked about.
Yes, yes.
In paragraph 2, Chairman Barney's disclosure in the public portion of the December 2, 2024 commission meeting that charges were pending against Director Jenkins Gray when that subject was not on the public agenda, was protected by the Sunshine Law, the City Personal Privacy Office,
Ordinance.
ordinance, I'm sorry, ordinance, and then you say, Chairman Barney, according to the sworn testimony of Commission Secretary Anthony Boyd. Now,
I'm sorry,
I believe
Byrd. It
that's
should be
Byrd.
Yes.
At any rate, so this filing was after you had taken his deposition?
Yes.
This is filed January 6th.
Yes.
According to sworn testimony of Byrd, Chairman Barney was dismissive of his caution made at that public meeting that such public discussion was improper, and responded it was not a problem because penalty of the charges was already publicly known when it was not public at the time.
Yes.
Okay, at any rate, so you've already addressed that.
Yes.
Is there anything else you want to add?
Not at this time.
Anything you want to add, Mr. Harris?
Judge, I think we talked about this particular motion, and as I understood it, it was denied. But be that as it may, I would just rest on.
I believe you're correct as to the, Mr. Norwood, do you believe I denied the motion to, I'm certain that we announced your motion to disqualify, you say the commission couldn't proceed as only 2 members. I know we said we denied that, and I believe at the same time, at the very outset, we denied the motion to, in the alternative, disqualified Commissioner Barney,
Yeah, yeah,
correct?
and we,
Okay.
that was denied.
You agree that that was denied at the very outset, 2-7, right?
Yes, yes, and we made a record on who voted and participated, et cetera.
We did.
Yeah, and there was a separate motion to disqualify. I don't know if that's on your list.
When you say of who voted the commissioners.
Yeah,
Okay, and there's a separate, what?
there's a second motion to disqualify that we filed that was to
Disqualify whom?
disqualify the commissioners, or in the alternative, motion to call the commissioners as witnesses. We argued that early on. We made an offer of proof on it, and that was denied.
That was during the hearing, was it not?
That was during the hearing, yes.
All right, and so, all right,
This keeps coming up, this issue of my,
I think, I mean,
so I can clarify it. Okay. We had ordered it to a meeting in November, and I thought it had been posted by staff, and they hadn't.
all right, I thought Commissioner Barney had made a statement on that. He wants to make a statement on that now, so,
Well, it just occurs to me, this public revelation that I brought forth in a meeting in December was based on the good faith expectation that in November, at a meeting of the commission, we set a date for a hearing on the 6th and 7th of January. It turns out the staff never posted that hearing, and in my 18 years on the commission, I'd never had it happen that one of our directives had not been acted. So I was under the belief in that December meeting that it had been posted, and therefore it was public knowledge that there had been charges brought against the director. Had I known they'd never posted the meeting that we ordered in a meeting in November, I wouldn't have said anything. And when I confronted the staff, they said, well, we weren't sure how to post it. And so they never did. that's why we later had to press the issue that we wanted the 6th and 7th to be dates. So my revealing in public was meant under the good faith expectation that the staff had posted the hearing that we'd ordered in a previous meeting in November. And I think the judge was aware of that, but I hadn't made that public.
Okay. Okay. I think then, and we just received this copy of the email that you referred to that was on your phone, I believe.
Yes.
That was addressed to you and signed respectfully, Civil Service Commission, with no name of the person who was sending it, correct?
Yes, yes.
And it appears it came from a general Civil Service Commission email.
Yes.
So it simply says, Civil Service Commission has obtained your request to issue an additional 3 subpoenas based on the rules. And it cites 2 rules.
Well, and the challenge, of course, is it appears that the commission has not seen the request or ruled on the subpoena, so.
Oh, Mr. Llewellyn has better eyes than I do in my old age. If you look in the line at the very top where in bold it says Commission, Civil Service, and then you've got the Civil Service Commission at stlouismo.gov. In parentheses, it then says, sent by Byrd
Yeah, that's
at
what I thought.
stlouismo.gov.
That's what
So
I
it
thought.
came from Dr. Byrd.
On behalf of the commission is
All
what he
right, now,
suggests.
you are offering this as an exhibit. Do you know what number you're up to, or you want to give us a number?
It'd be 42.
Exhibit number 42, Director's Exhibit number 42.
Just out of curiosity, are you able to, Attorney Norwood, pull up for the assistant, the time in which Anthony sent that on behalf of the Civil Service Commission? There's no time.
There's no time on it, or date for that matter,
Well, it was 1:15, I know the date, and the time,
but how do you know the date? Is that your notes or something? Because
Well, it's my-
looking at it, I don't see a date.
well, I'll show you my phone, and what it says is on the email transmission, January 15, 2025, at 7:38 a.m.
All right. You show that to both the commissioners if you
Oh,
would.
I'm sorry.
January 25.
No, January 15.
15, I'm sorry,
Yep.
January 15th, 2025, at
Thank you.
what day, at what time?
7:38 a.m.
7:38 a.m. All right. All right, Exhibit 42 be admitted into evidence. All right? So with that, the next one on the list is number 10, is a deposition request with Exhibit A deposition transcript. Now, is this moot? This is about Byrd's deposition, isn't it?
Yes. Is that what I think we requested to be able to use his deposition testimony to preserve his testimony because we were.
It was taken, it's already been put in
Right.
evidence
So
by
it's-
both parties.
Yeah.
Well, we had a back and forth about things they wanted to exclude, we wanted to exclude, and then ultimately, we agreed that we would play our portions after the tribunal denied our motion to keep out certain portions. They read their portions, and then we were allowed to play in response. I believe it would be permissible under the rule of completeness anyway, in terms of, since they played a chunk of it, we were able to play our chunk.
Right, those were both admitted into
Yes.
evidence, right?
Yes, so there's no issue with that, right?
So, okay, so as far as anything about that, that's all moot, right?
Well, only to the extent that we had objected to certain portions that they had read, that was overruled. It tied to the motion on personal items, personal.
But that's in the hearing record.
It's in the hearing
In other words,
record
we had
now.
a discussion and the motions were discussed and the ruling was overruled was at that time. That's in the record,
Yes,
right?
it was, theirs was played over our objection, ours was played with their consent. That makes it clear.
All right. All right, then number 11, and that is, I believe, the last one. No, there's a number 12. Or no? Number 11 is motion to quash subpoenas 2, and I think you've referred to these earlier. Office of Mayor Jones, Comptroller, and IT Services of the agency records. And you got exhibits, Mayor Jones subpoena, Comptroller Office subpoena, ITSA subpoena. Okay, is that moot now or what?
That was the city's motion, I think.
Yes. Or is that more or less wrapped up in your motion to quash subpoenas of the mayor and the others? I think it would be included since we haven't ruled on that yet.
Yeah, I think I think that's wrapped up in there, because a lot of the same arguments I think will be made with respect to, political interference and the like.
Okay. All right. Is number 12 a motion? I don't see, is there anything nothing under that tab?
Yeah,
Extra tab, okay, fine.
yeah, we ran out of paper.
All right, now that's those motions. The city, obviously, we've talked about, the city has this motion to quash the subpoenas, which is still pending. The motion in limine to exclude evidence relating to the political motivation or uneven enforcement of the vehicle policy. Right?
Right.
And by the way, before I get into that, I'll just mention one other one that was taken up during the, it was mentioned that there was a motion to schedule a hearing filed by the appointing authority that dealt with scheduling, and we discussed that, and that's moot, right? Now, in effect, I mean, at the time, we did not schedule everything that you requested here, right? But on the other hand, we did set future dates, and ultimately, I thought, with the consent of both parties.
We had set future dates, but I think one of the challenges we had was we ended up setting it aside until we determined what the commission was going to do with the litany of witnesses that the director is seeking to call.
Well, we set today, we set the 10th, we set the 11th.
Right.
And the question then becomes, do we need all of those days, or would we need an extra day?
Well,
Which is unlikely, but depending on which witnesses we're going to
we
call.
cross that bridge when we come to it.
Right,
Right?
right.
So, but this is moot as far as it was discussed with scheduling earlier. I mean, we still have scheduling questions, but that'll depend on where we go.
Sure,
Right?
sure. Correct,
Okay.
correct.
I just want to make sure that I can, I know what is still out there, all right? And this one is not, I don't think. Okay. So that brings me then, I think, is there anything else before we get to the motions which, wrap up together? The motion in limine is the city's motion to exclude evidence relating to political motivation or uneven enforcement of the vehicle policy. We said that would be considered during the hearing, right? We have not ruled on that one way or the other, correct?
we've objected to it, but yes.
There's been no ruling on it, right?
There's been no ruling.
Okay. And then that relates in part to the city's motion to quash subpoenas of the mayor, and I realize what you said about that was sustained as to the mayor earlier. But then the others, the comptroller and city councilor and the airport director, are the other three besides the mayor that the director wants to subpoena and bring in as witnesses, correct?
Yes, and I understood that in light of the briefing on the retaliation interference, that would have a bearing on whether or not the mayor would be allowed to testify.
Correct. Correct. All right, so that brings us to the matters that you have filed over the weekend, I believe. We, as I said, we got the things that you filed, and what we got, just to put it on the record, to be clear, from the city, we got suggestions, appointing authorities, suggestions in support of its motion to quash and motion in limine. And attached to that as an exhibit was a pleading that was filed as the response of Defendant Civil Service Commission, Barney Llewellyn and Jane Doe, in opposition to the plaintiff's request for preliminary writ of prohibition of mandamus. That was filed in the Circuit Court of 22nd Judicial Circuit in cause number 2422-CC11-699, which was the motion for preliminary writ and so forth that was filed by the director, which ultimately was heard by Judge Moriarty, and Judge Moriarty denied that. We referred to that earlier. That's their exhibit, the commission response to that. That's all we got from the city, correct, Mr. Harris?
That's correct.
And then from the, and I'm referring city appointing authority, I think everybody understands it's practical purposes that we know who I'm referring to. City's a little shorter.
Yes.
All right, and then for the director, we got supplemental written offers of proof for Mayor Tashara Jones, Comptroller Darlene Green, City Councilor Sheena Hamilton, Airport Director Rhonda Ham-Newberry. We got that as one document, and the other one was Director Jenkins Gray's brief in opposition to the appointing authority's motion to restrict evidence of political interference, political retaliation, and/or political discrimination. Correct?
Yes.
Now, I believe that covers all of the motions that were heard, might be outstanding or pending. So let me just say, with regard to that, as I understand the city's position as set forth in its suggestions, it cites first of all, Article 18, Section 16 of the city charter. I believe that's also cited by Director Gray. The city argues that what it says in Article 16 is that no recommendation or question under the authority of this article shall relate to the race, political, or religious opinions, affiliations, or service of any person. And of course, I don't know that the charter has it. I think you've added, emphasis added, you say yes, that you've italicized, no recommendation or question under the authority of this article shall relate to the political opinions of any person. And so the city is arguing that that means that any reference to any political opinion of Director Gray or of any other person, which I suppose would include the mayor and any other person, can be considered in in this case. The decision of the commissioners could not consider those. Am I correct, Mr. Harrison? I'm going to give you an opportunity.
Yeah, that's correct.
All right. The city also argues that consider hypothetically two possibilities. One, director committed malfeasance and there is no allegation of political interference or ulterior motives by the appointing authority. And the other, the opposite, director committed malfeasance. Now, you're assuming that in both cases. That's obviously one decision the commissioners would have to make, whether or not the director committed malfeasance. But you're saying, assuming for a moment that that was done, and there are allegations of political interference or ulterior motives, you're saying that even if there was, you say allegations, that in either case the commissioner bases its recommendation on whether or not the director committed malfeasance. You say that's required by Article 18, Section 9Q. Therefore, it does not matter whether there are allegations of political interference or ulterior motives by the appointing authority. Now, obviously, allegations is not proof, but is the city's position that if there was evidence of political interference, political ulterior motives by the appointing authority, if there was that evidence, that that could not be considered? Is that the city's argument? Because that's the way I understand it, the way you've presented it here.
Well, the position is that the commission, which is the body that has to, decide these issues in terms of whether or not there's malfeasance and whether or not to recommend termination, that the commission cannot take into consideration any political opinions, affiliations, or I forget what the other term is, of any person. That is the director, the appointing authority, the individual members of the commission, or anyone else. Those aren't the issues that are before the commission. What's before the commission is whether malfeasance was committed.
That sounds like a yes.
Pardon me?
No, I was saying that sounds like a yes to your response to your question.
Yes. Okay. All right, and then you cite some cases here. And then you say in page 6, section 3, political interference is not even referenced by the city charter. Now, and you say in political interference is referenced nowhere in Article 18. Okay, and certainly the words, quote, political interference, end of quote, those two words, that is not referenced anywhere, correct?
Correct.
All right, and Mr. Norwood, you agree that those words of political interference are not referenced. But then you reiterate what you argued earlier, that the commission, by section 16, cannot consider the political opinions of any person, right?
Correct.
All right. And you cite a case of Kirby versus Nolte, where the Missouri, I believe it was the Supreme Court, 1942 case, which is right after the city charter was adopted, if I believe my history is correct. I don't know that it's been in evidence, but I believe city charter was adopted, I believe, in 1941. And shortly after that, there was litigation that took place because of some of the employees that might have been terminated after the charter went into effect. I think this case was one of those, perhaps. And that's where this ruling came out, that you say that the ruling said the director of personnel, the court did not hold that the director of personnel is forbidden from discussing personnel matters with elected officials, nor did it prohibit elected officials from giving their input to the director of personnel concerning matters of employee compensation, benefits, working conditions, or other personnel-related topics. That's what Kirby versus Nolte case dealt with, correct?
Correct.
All right. And then you cite another case, City of St. Louis versus Vervis Jones et al., number 904-00246 in the 22nd Judicial Circuit, September 1990. And you get a quote from there. I think I know which judge might have written that, but at any rate, you don't cite which judge it was. For many years, it was contended that employees could be fired whenever there was a new administration because of the spoil system. Well, that's the old system, and you cite a case from, again, 1942. The Civil Service Commission was created to avoid such results. You say the Article 18 contains provisions designed to achieve this goal, such as Section 16. All right. Therefore, the civil service system is designed to ensure that employees and the director of personnel are hired, fired, disciplined, and paid solely on the basis of merit and fitness, and not because of their political affiliations. All right. Mr. Harris, it seems to me that that would imply that if an employee was being disciplined because of a political affiliation, that would not be something that would meet what the civil service system was designed for. Isn't that what you're saying there yourself?
Sure, and the question is, what does political affiliations mean? What
Sure.
does political opinions mean?
Sure.
And this follows right on the case that was cited that talked about, this system in which there was a change in administration and everyone got fired. And so the charter provision was set up to prevent that kind of activity from happening. So that's what this is about, that if someone comes in, a new administration comes in, and the director of personnel is of a different party, and other employees are of a different party, and they say, you're all out, that's what this provision prevents.
All right. Now, going to Mr. Norwood, your brief, the question I think I have for you somewhere in your brief, you cite, I believe it's Section 7. Do you not?
Section 16.
Or was that? No. Go
Section
ahead.
7G.
Where was that
Section
cited?
2,
7G is cited on
page
what?
5.
Page 5. Okay, thank you.
Specifically, 7G. And then Section 2 of Article 18 is also cited on page 5
Also on page 5.
and 6.
Okay. Now, just you quote a portion of Article 18, Section 7, which is titled the Commission Powers and Duties,
Yes.
and specifically Section 7G concerns reinstatement of employees in that the commission shall, and you have in quotes, order the reinstatement without loss of pay of any employee who has been discharged, demoted, or reduced in rank or compensation for religious, racial, or political reasons.
Yes.
All right. Now, it seems when you put that and what Mr. Harris had and what he just said, you both agree that if there is, that the first question the commissioners are going to have to decide as they decide this case if I'm correct, is what does the city charter mean when it says in section 7G, political reasons? What do they
Right.
mean by that?
Right.
And you have used the terms throughout political interference. Well, the word interference hasn't been used in any of the documents that I know of, but it's in effect the same thing as I understand your argument.
Well, if I may.
Political interference, political reasons, I mean.
Well, let me start with section 6.
All right, well, let me just put it this way. I'm putting that out there. I'm going to give you both the chance to address what you filed. So, first, the city, you have your brief in opposition, I'm sorry, your motion is to exclude evidence relating to political motivation. Now, are you still wanting to pursue that? Or, from what we just said, is the question of what is political motivation, that's an issue, I suppose. In other words, if any particular evidence were to be proffered or preferred, I don't know which way to pronounce it, the question would be at that time, should an objection be sustained or overruled if there's an objection that it's not relevant because it's not evidence of political motivation? I don't know how otherwise to proceed on this, but go ahead. It's your motion. Do you wish to still proceed on this motion and eliminate?
Absolutely.
Or the alternative would be to simply pursue your motion to quash the subpoenas.
So, yeah, absolutely. I believe
All right.
that, I
Go ahead
believe,
and make your argument on the motion and eliminate.
yeah, I mean, and it's, I mean, I believe it's set out in our suggestions and support in the actual motion itself. You know, that,
You know what? I'm sorry, mister, but rather than let you get halfway started here, Mr. Flellen has a business thing that he has to take care of here, and so it is almost the lunch hour. I think what we will do is recess for lunch and a little extra time for him to get that. How many?
I think we should probably adjourn to consult with our lawyer, so we'll have a motion, so over the noon hour, we could consult.
Before they argue the motion? In
Well-
other words, they haven't given their arguments on
I
this
know
last
that,
one.
well, we don't have to include that part, but I
Oh,
was
okay,
saying.
on
that
the
he-
other things,
Yes,
on the other things.
so with a motion that we adjourn and.
No, recess.
No.
Or-
Recess.
Yeah.
In order to consult with our attorney during the lunch hour. And I just want to put that on the record.
Sure,
And
sure. Well,
that's my motion. Is there a second?
is that a motion to go into executive session? or-
Yes,
Right.
that's the same thing.
Okay, so it's a motion to recess, and the commission will go into executive session, and over the lunch hour, we'll consider the matters that we've already discussed. We will not consider the motions that we were about to discuss that were
That's
filed
correct.
yesterday, but we can perhaps deal with the other things, and then when we come back, we'd hear your arguments on what was done yesterday, right? Okay, that's what we'll do now.
Secretary will. I'm sorry.
Call the roll on your
Yeah.
motion.
Yeah, call the roll.
Chairperson Barney.
Yes.
Vice Chairperson Llewellyn.
Yes.
Okay. Motion.
So what time are we?
Motion passes.
We'll come back at 1.
1 o'clock?
Well,
Yeah.
I think we need to get a little extra.
Let's just say 1:15.
1:15.
Yes, thank you.
Thank you.
All right, so 1:15. Okay, we're recording. So after the lunch break, we heard in the morning the parties' arguments on these various motions, and we're trying to just make sure the record is clear here. Now, as I've mentioned at the outset of the hearing back in January, the commission has asked me to serve as the hearing officer And in doing that, I'm in a quasi-judicial capacity where I'm making rulings on the admissibility of evidence and on various motions, which then it's up to the commission to adopt or not adopt what I do. So I'm going to go through and state my rulings on each of these motions that are in any way pending. And the first one of which I might think is moot at this time. This was a motion filed, we didn't mention this morning, but there was a motion filed back in January, I believe on the 14th, second week of the hearings, by the director, motion to reconsider all motions not heard at the January 7th, 25 hearing in violation of the notice of public hearing and in violation of the hearing notice requirements. Well, whether or not that was applicable at the time, it's moot now because this morning we have heard all of those motions. So next, we go through, there was the motion to disqualify or quash the investigation. That is denied. The legal basis cited in that motion is not adequate. Same for the motion to disqualify the city councilor. That is denied. The motion to disqualify the commission as a whole from hearing this matter, and in the alternative to disqualify Commissioner Barney is denied. There's been a number of things stated and argued as to why that should be granted by the director, but I don't think any of those things stated a sufficient basis to justify granting the motion, so that motion is denied. We mentioned it this morning, motion to quash city's document subpoena is moot, as is the motion to exclude testimony related to family matters, and the motion to strike the city's motion to quash as untimely, and the motion to strike, now the motion to strike opposing counsel's motion to quash the subpoenas, we did hear that, I believe, during the actual hearing itself, but that is denied. The motion to strike, the motion to quash the subpoenas. We're going to hear the motion to quash the subpoenas this afternoon. So the motion to strike it is denied. The motion to preclude the use of a hearing officer is denied. The motion to exclude evidence of any violation not specifically contained in the notice of hearing, again, at the outset of the hearing, I ruled that on that, that motion was in effect a motion in limine. It could not be ruled on because it would have to be ruled on as any evidence was offered. There'd have to be an objection and a ruling at the time, and I think that's the way it was handled during the hearing. So that motion itself is denied or moot. I believe it's moot, but if not, it's denied. The motion to preclude the adoption of new modified rules, that we heard argument on the first day of the hearing, right at the outset, by both parties, and the motion was denied at that time. So that's already been ruled on. The motion for a continuance based on defective notice, and the motion for a continuance to allow a judicial ruling on pretrial motions, those are both, again, denied. Those were denied as submitted in writing, and after further statements by the parties, argument this morning, those remain denied and are denied today by me. And last, on the first list was the motion to preclude the hearing from occurring in the absence of a three-member commission. That is also denied. As the legal basis for the motion, we do not believe is sufficient to justify the motion. So I think that takes care of all the motions. Other than the ones that were filed over the weekend. Am I correct? Are there any out there that we haven't addressed?
There were the two motions for continuances, one predicated upon the untimely and in certain cases, non-production of records, and then the other one predicated upon the ability to go down the hall to get a determination on these determinations
By down the hall, you mean
to circuit court.
to circuit court. So, motion for continuance, now this was filed when? I don't think I have it in this packet.
Yeah,
Is
we
it,
covered
is it in your binder? Is
Yeah,
it,
we
is
talked
that where it
about
was?
this morning. Yeah, we talked about it.
Oh, we did, okay, I think that was one of the ones perhaps in this binder.
Yeah, yeah.
Motion's TOC, right? Okay.
Those
Yeah.
were 11 and 12, and I thought those were denied.
Well, 11 and 12 were denied, yes.
Okay.
I think that
And they're re-denied.
there was another binder, wasn't there? Yes. Here's the one that I'm talking about that you gave me that had a couple other motions in it that were not in that whole first group. When we went through them all this morning,
Yes.
but are you talking about motion for continuance based on defective notice, newly acquired documents, and failure to properly respond to subpoenas? That's tab number 5 of your,
Yes.
all right. I thought that the motion for defective notice was one of the ones we did cover. Yes, isn't that number 11? Motion for continuance based on defective notice, new evidence, non-response to subpoenas. So that was denied. I just announced it, I think.
Yes.
Okay, just want to make sure. So we did cover that one. Was there any others in this?
There was the motion to continue to allow judicial review. That was the other one I think you denied as well.
Yes, that was number 12, I think, wasn't it?
Yes.
Yes, I announced that was denied. Right, so I covered all of those. I don't think there's any more, are there, that are out there, other than the ones dealing with motion in limine to exclude political interference and the motion to quash the subpoenas, various officials and agency directors. Okay, and that's what you're going to argue. Now, those are what I have, after hearing your arguments this morning, I've considered them. Those are my rulings. Does the commission agree or
Well,
not agree?
let's make a motion to adopt the rulings of the hearing officer as just outlined. Is there a second?
I'll second.
Clerk will call the roll.
Chairperson Barney,
Yes.
Vice Chairperson Llewellyn,
Yes.
motion carries.
Okay, all right. So, that then gets us to the arguments of both of you on what you filed over the weekend. Mr. Harris, you were starting on that when I cut you off before lunch, so we'll let you argue your motion to exclude or limit evidence and/or can you argue it all at once? The
Sure.
motions relating to the subpoenas and the different officials and,
Yes.
okay. So go ahead, you may proceed.
And I'll try to be brief and just note again that you know, our arguments are stated in the drafted motions themselves, and I'll just kind of touch on a few things. We continue to you know, we maintain that evidence of political motivations and the like should not be admitted in the matter. I mean, if we are allowing evidence of the political motivations of anyone, then what we're doing is we're asking the commission to consider that evidence. We're asking the commission to consider, you know, political differences or policy differences of the folks involved in rendering its decision. And that's precisely what should not happen. Evidence of pretrial motivations is irrelevant. Article 18, Section 9Q, which is the provision of the charter that is at play here, authorizes and commands the commission to make a determination as to whether or not the director committed malfeasance and make a recommendation to the mayor in that regard. And that's it. It doesn't. It does not permit the consideration of evidence of political motivations. In our previous, in the original motion that we filed, and in the discussion that we filed over the weekend, we again pointed to the Rorda case that we've talked about before, with the police officer who was terminated, who made arguments that, you know, he wanted to put on evidence that no one's ever been terminated for what he did, and the chief of police had it out for him. That review board did not allow that evidence in, and that was upheld. We've pointed to the Stubblefield case. And in Stubblefield, the commissioner of the Department of Corrections was terminated and for fiscal mismanagement. And he alleged that his termination was nothing but a pretext, and that the real reason he was terminated was political, some political fallout from inmates who had escaped. And the civil service found that it was his fiscal management that warranted dismissal, and the reviewing court, you know, reasoned that any political motivation was irrelevant. The question was not this idea of the real reason for the discharge, but the question was whether or not there was just cause for his dismissal. In other words, did he engage in fiscal mismanagement? Both Rorda and Stubblefield are the cases that this court should look to in rendering its opinion here. The question again, under the controlling provision of the charter, is whether the director committed malfeasance. Not, you know, what are the political differences between the parties that are involved. I mean, the commission's own filing in the court case in this matter, I mean, agrees with us, agrees with our position. I mean, in the court filing, the commissioners were defendants hailed into court by the director, and they had to respond to the petition. And this commission said that the Civil Service Commission will consider charges that plaintiff Jenkins Gray was guilty of nonfeasance, malfeasance, or misfeasance in office. The Civil Service Commission will consider whether the testimony and evidence presented at the hearing supports the charges. If the evidence supports those charges, the motivation for bringing the charges will not matter. And this commission relied on the Stubblefield case in making its argument. And so even if plaintiff manages to produce evidence that political motivations contributed to the pursuit of charges of wrongdoing against her, it does not constitute discrimination or retaliation for the exercise of constitutionally protected rights. If the evidence supports the charges, the motivation is irrelevant. And that was this commission's position in the court hearing. And so
Say that again. What you just said was a quote from that filing?
Yes. if the evidence supports the charges, the motivation is irrelevant. Again, relying on Stubblefield. I mean, so if in this hearing, in this proceeding, if the evidence which we have, put forth in this matter, if the evidence supports the charges that the director committed malfeasance, that's it. Political motivation is irrelevant. Now, in the unfortunate event that this commission has changed its mind or has changed its position from what it filed in the court case, and they allow this some evidence in of political motivation, we still think, turning to the motion to quash, we still think that the witnesses that they would like to call to put on some evidence of policy differences and whatnot should not be allowed, as we argue in the motion to quash, for the various reasons stated therein. One being that they are seeking these high-level executives, including the mayor, the comptroller, the city councilor, the director of airport operations, to put on evidence of whatever they are calling political motivations. So there's federal case law, there's state case law, saying that, burdening a city government or an organization by hailing its high-level executives into court to testify on these issues is unnecessary and improper, particularly where there are subordinates in their charge who could come and testify instead. And those subordinates could be folks like Mr. Boyd, Ms. Baker, who have testified. They've gotten their bite at the apple for those witnesses. And I assume, again, in the unfortunate event that evidence of political something is allowed in here, they can call Mr. Boyd, they can call Sarah Baker to the stand to testify on those matters. There's no need to call these other witnesses, the mayor, these directors, the city councilor. None of them have any personal knowledge as to the underlying facts in the case. None of them have personal knowledge as to whether or not, or as to what happened on this trip to Jefferson City. So for all of those reasons, we would request that our motion in limine on this issue of political motivation and on this issue of uneven enforcement, as well as our motion to quash these witnesses from testifying, we request that those motions be sustained.
All right then, Mr. Norwood.
Okay, where do we start? Mr. Harris referred to, what did you say, whatnots? Well, there are a lot of whatnots in this matter. And his reading of the charter, well, no, let me back up. First of all, I want to go to this filing made by Mr. Garvin on behalf of the commission, wherein he cites the very cases that they cited in support of why some of this stuff would come in. And this is part of the problem, right? Mr. Garvin, great lawyer, great human being, probably a great Christian. He represents the city. His job is to basically do what they're doing, which is to pursue my client based on these charges. There's nothing wrong with that because that's his charter-given responsibility. So he goes before Judge Moriarty and he files on behalf of the commission this position statement that wasn't adopted by Judge Moriarty, by the way, because her ruling was simply exhaust your remedies, go to the commission, which is why we're here today. And so bootstrapping the arguments made by the appointing authority in support of the commission's determination today on this critical factual issue that we believe, for various reasons we set forth in our filings, and per Judge Moriarty, this is your baby now. This is what you all have to decide. You all have to decide whether or not, and we're not talking about the violation. The violation is not really in dispute. She didn't know about, if we believe her, she didn't know about the rule, and she made recompense. But does that rise to the level of malfeasance? That's part of what you have to decide. But the charter provisions that have been butchered, a careful reading of those charges, or of the charter, makes clear that it's not quite what it's being made out to be. First of all, the broader picture. We set forth 3 fundamental bases for why my client, whose job, career, reputation on the line, is entitled to something very simple, and that's to present a defense, right? Article 18, Section 9Q of the Charter says, quote, the personnel director may be represented by an attorney. Okay, we can check that box. A couple of attorneys, in fact. It also goes further and says, and shall be entitled to present witnesses in her defense. Shall be. There's no discretion in there saying the witness Reggie don't like, Mr. Harris doesn't like, they can't call these witnesses. And we're not just talking about calling any witnesses, and we're not just talking about calling the mayor just because we want to hang out with the mayor. She is the king, well, more appropriately, the queen pin of what we suggest is political retaliation, political interference, and political discrimination. You posed the question to Mr. Harris. Are you saying that if they establish all of that stuff, that vile stuff, that it can't come in? And his position is no. That's like saying, because note that the provision at issue not only prohibits political discrimination, it prohibits discrimination based on race. It prohibits discrimination based upon sex. It prohibits what Title VII and various other anti-discrimination provisions prohibit. So in his view of the world, if this were a race discrimination case, we couldn't present evidence of race discrimination to mitigate and support the defense expressly provided in the charter that says that's prohibited. That's what he's arguing. Essentially, remove that provision from the charter, which is improper, okay? So, what do we have? We have those charter provisions, but we also have something important. I think they call them Missouri Supreme Court en banc decisions. We've got the State X-Rail Pedroli case, Pedroli versus Hartenstein, 163 Southwest 2nd, 963, Mobank, 1942, cited at page 3 of our submission. And they talk about the fact that the charter was adopted in 1914, okay? And then in 1941, the people, not Ron Norwood, 'cause I wasn't around, I feel like I was around, but I wasn't around in 1941, the people amended this charter specifically, and according to the Missouri Supreme Court back in 1941, to provide for a civil service commission which is authorized to consider appeals by employees who have been discharged for political reasons. It didn't say, not this political reason, it said reasons, which could include political interference, which would include political discrimination, which would include political retaliation. No, I'm arguing to you.
Well,
I know that. but-
Norwood, the commissioners are the ones that are going to
No,
make the
no, no,
decision.
no. I'm a little theatrical. My chi is high, and I'm trying to bring them over from the dark side. But that's another question. So that's what the Missouri Supreme Court says in Pedroli versus Hardenstein. And there was a companion case in that same year. State X Rail Pedroli versus Kirby, 1942, says at the site 163 Southwest 2nd, 964, it says at page 965, quote, the commission, I think that's you all, or at least most of you all, we're missing one. The commission is authorized to consider appeals by employees and to order reinstatement of any employee without loss of pay who has been discharged for political reasons. Those great Missouri Supreme Court justices back then recognized the fact that we could be sitting here in 2025 in a situation where a mayor who doesn't like civil service for whatever reason, who doesn't like an independent director of personnel for whatever reason, who then sets in motion processes designed to castigate her, to damage her reputation, to intrude on her marriage. The very stuff that they recognized back in 1941 and 42 should not happen when the charter, as adopted by the people, says we want merit-based civil service. On the merits, not because we don't like her, not because we don't like her position on maintaining the very system that you commissioners swore an oath to uphold, to prohibit queen pins, king pins. Nobody's done it. And there's a reason. Because nobody has looked at this thing and said what he said is that we can ignore all of that and we can politically interfere and we can politically discriminate and we can politically retaliate, which is his argument. It is farcical in nature because it is directly contrary to the express provisions of the charter that binds us all. He read the first sentence of, well, let's read on in terms of what the Missouri Supreme Court said in the Hartenstein case. The purpose to provide a modern and comprehensive system of personnel administration for the city, whereby economy and effectiveness in the personal services rendered to the city, and we talked about this earlier, fairness and equity to employees. She's an employee. She's a very high-level employee, and technically, other than the fact that the mayor is elected and the chief executive, her role is as important as the mayor as it relates to an independent civil service of 4,500 to 5,000 employees. Her job and our job and your job is to protect the integrity of the system. The system was designed to be a buffer, more than a buffer, to be a shield against what we're alleging. Now, whether or not you accept it or not, we recognize that. But the evidence is the evidence, and we already got evidence in the record about political interference, about efforts to subvert civil service, cronyism, patronage, the very things that are antithetical to independence. And because she had the moxie to stand up to the mayor, in our view of the world, is why she's sitting here today. Because we talked about it, progressive discipline. They could have said, okay, you violate the rule, you paid some money, but we're gonna suspend you for a week or 2 weeks, okay? Let's get back to business and continue the wonderful work you've been doing for that department. That didn't happen. And the question is why? We talk about res ipsa loquitur, Latin term, means the thing speaks for itself. And the question is, why are we here today for $170.30? And I know there's been intimations about, well, she put an employee in a precarious situation. No suggestion that that was her intent. In fact, the only evidence in the record is that her intent was to go retrieve some personal papers, and some things happened along the way, or actually on the way back. And that's fine. But that doesn't rise to the level of malfeasance. There are a whole lot of off-ramps that the mayor could have taken to protect the city if that was the real reason. But that's not the real reason. And we know this because we saw a little clip of her, and we got more clips, where she made clear that she believes civil service should be in the mayor's purview, meaning no independent civil service. I mean, you rarely get evidence where somebody goes on record and says, I think it's outdated. I think that system is a crock. I think those people back in 1941, they didn't realize what they were doing. But not only in words, but let's look at deeds. We've got evidence of deeds, situations where she has directly subverted civil service. And not only did she subvert civil service, over the course of time, both before and after we got into these whole charges, but in fact, that subversion continues. January 25, 2025, 4:40 p.m., Respondents Exhibit 41 attached to our filing. They're still subverting the process, still placing unqualified employees into positions that these folks aren't qualified for, which in and of itself is a violation of the charter. So let's look at the charter. The charter, section 16. He focused on the first section, this is on page 4 of our filing, on the first sentence of section 16. No recommendation or question under the authority of this article shall relate to race, political, or religious opinions, affiliations, or service of any person. So he says, well, that means you all can't consider politics as part of your decision. And he's right. But the recommendation is not the ultimate recommendation of termination. The recommendation started when Mr. Boyd, on behalf of his boss, launched this ship with this false letter about a hearing being set that none of these commissioners knew about. That's what the recommendation was. Terminator. Let's go forward with a public hearing. So to the extent that that recommendation is politically motivated, this charter prohibits that. But what he didn't read was the second part of the same section, the next sentence. It says, no person, she qualifies, shall be appointed to a position in classified service hereunder, meaning those cronies, those unqualified cronies, could not be placed in these positions because it's not merit-based. So they violate the charter by placing unqualified people, and then they go after her for fighting against the placement of those unqualified people. But it goes further. It says, no person shall be appointed to a position, demoted, think firing is a demotion, removed, this is a removal, nor in any way favored or discriminated against in any matter within the purview of this article. The purview of this article includes, voila, section 9Q. The purview of this article is the entire civil service system. And under his analysis, she has less protections than, say, someone who removes snow, since that's something that's hot right now in the press. They have more protections than she would have as the director of personnel is their position, right? And it talks about discriminated against in any matter because of race, political, or religious opinions, political affiliations. Now, that's what he's talking about, because the cases he's talking about related to political affiliations, and they latched on to affiliations. Or service. Her political position, because she's not a politician. She's not sitting here as a Democrat, not sitting here as a Republican. She's sitting here as an independent leader of civil service, and her political position is simply that the charter should be enforced as written. That's the political position. And we have a mayor who says, no, that shouldn't happen. Words and deeds. The attachment, Exhibit 41, is a prime example. It shows a situation where the mayor, through her staff, I'm sure they just go off on their own without conferring with the mayor and just run the city, is their position. They go off, meaning the mayor and her subordinates, place somebody or seeks to place somebody in a position they're clearly unqualified for. She, in advance of that, says, no, here are the rules, you can't do it. First of all, he's still a political appointee on the mayor's payroll. First of all, so before you do anything, he can't have his foot in one civil service side and one appointee political side. He's got to make a choice. So he's got to resign from the city, from the mayor's staff, and then apply, like every other person, for the position. But he couldn't apply because he wasn't qualified for the position. So what happens then? And this is what the evidence is going to show. The evidence they're trying to keep out, and I see why. They shipped him over there anyway. Gave him an office. And the director's pulling her hair out. I mean, in addition to the fact that she's fighting for her life and fighting for a job here, she's like, well, wait a minute, I still have to make sure we maintain the integrity of the system. There's a line in a movie where they say she's the only class in this act. And in that sense, that's absolutely true, because she's doing her job, fighting for civil servants, and also fighting against this to protect the system that the voters decided is best for this city. But there's more. Specifically, Article 18, Section 7, under the title Commission Powers and Duties. Powers, meaning the power to do it, and the obligation to do it. It's Section 7G. Says, and it concerns reinstatement of employees who might have to be terminated. And the whole thing is that this process, this unique process, the normal thing you all deal with is the fact that somebody's disciplined and they come to you for review. That's the problem. This is different. And it's not spelled out clearly like it is with regular other civil servants. But it says the commission shall order the reinstatement without loss of pay of any employee who has been discharged, demoted, reduced in rank or compensation for religious, racial, or political reasons. Interference is a reason. Discrimination is a reason. Retaliation is a political reason. That's not me, that's Section 7G. That kind of rhymes, but I like it. That's what the charter says. That's what you all swore to uphold. The cases they cite, they don't talk about Section 7G. They don't talk about Section 16. But there's more. Section 2 of Article 18 makes clear, Section 2A, merit and fitness. The cornerstone of any independent civil service system. We hire based on merit, we hire based on fitness. And we can't consider politics that ultimately could corrupt a merit-based fitness-based system. 2A says, all appointments and promotions to the positions in the service of the city and all measures for the control and regulation of employment in such positions and separations therefrom shall be on the sole basis of merit and fitness. Sole basis. Meaning that even if there's a little political interference, even if there's a little political discrimination, even if there's a little teeny weeny bit of political retaliation, that's not solely based on merit and fitness. And that's no different than any other discrimination case, be it sex, race, age, whatever. That if you have what they refer to, and we cite a case in our filing on page 7, the Barnes versus Bosley case, 745 F. 2nd 501, 8th Circuit, 1984. First Amendment case. But when you really look at the anti-political opinion provision, anti-discrimination opinion provision, that's really baking into that the First Amendment protection for those political opinions. And in that case, it says, quote, in mixed motive cases, because that's what we're talking about. They may have some reasons where they think maybe it justifies rising to the level of malfeasance or something like that. But this is a mixed motive situation because we believe that the overwhelming evidence shows that there are more sinister motives involved. It says in mixed motive cases where the evidence demonstrates that both legitimate and illegitimate motives may have prompted action against a public employee who engaged in protective conduct, the allocation of the burden of proof is dictated by Mount Holy City School District Board of Education. Supreme Court decision, 1974. This is a mixed motive situation. You don't have to believe our evidence, but under the charter, where we have a right to present a defense and witnesses, under the notice that said we had a right, and under due process, where we have a right to present a defense, in a mixed motive situation, we have the right to lay out our case, as wet as it might be, according to Mr. Harris. Because to me, it's fundamental. The person at the top doesn't get a pass with respect to testimony, particularly when the testimony is that it's the person at the top that's doing the discrimination based on politics, that's doing the retaliation based on politics, that's doing the violations of the charter based on politics. Being able to place cronies, being able to fill patronage positions, those are votes. An unqualified cousin of a donor, let's make them director of personnel. An unqualified person, and for whatever reason, a relative, let's take them off our payroll, which is political and not protected, and let's give them protected status as civil servants. That's what this whole thing is about. That is wrong on all levels, but clearly it's wrong because it violates the very charter that this city is built on. We believe that the evidence, there is evidence about the fact that this week or last week, Mr. Jared Boyd, who you heard from, went over to one of our subordinates and effectively offered that person the position when we're here deciding whether or not there's going to be a position to be filled. I mean, what does that tell you? We have direct evidence of interference. We have circumstantial evidence of interference. And what we're saying as it relates to top to bottom, the mayor is the one. She is the one. And if she gets on the stand and says, I didn't know anything about anything, was that the Sergeant Schultz defense? There's something to say about that too, particularly for somebody who's running for office. You let your staff run around and do all of this stuff without you even knowing about it? That's something you all should know, right? Flip side to that is what is the truth, that they were reporting to her on the regular. She knew exactly what was going on. She knew that this letter was going out. She knew this proceeding was going forward. So we should be able to hear from her and say, I wasn't motivated by political interference. And all of those cronies I put over there, that was for other reasons. I mean, that's what fact finders are here to decide. And if the charter says it's the defense, how can the commission say it's not without rewriting the charter? And that's our point. The law supports us. The language supports us. The notice supports us. Due process supports us. And all we're asking for is a fair trial. Because if you say none of these people can testify, well, maybe we ought to just pack it up and go home. Or go to the Court of Appeals, or wherever you go from here. Because that is really what you all, according to this, duties to find the truth and make a decision based on truth. And not on supposition, not on theory, based on evidence, sworn testimony. That's the mayor. The evidence, we believe, is going to show the city councilor is involved in multiple levels. She's the one who grabbed her by the coat and said, come here, director. You better watch out. Because the word out there is that you are trying to sabotage not just her reputation, her political aspirations. This is what the testimony would be, if she tells the truth, and I'm sure she will, from the city councilor. Told her that you better be on the lookout because the mayor believes you're trying to sabotage her campaign by not hiring fast enough. And she talked about this earlier. I mean, she got the response, being a professional, she said that's not true, but okay, let's do something. And she reached out and connected with the appointing authority of that department and make sure things, I mean, because that's how she rolls. That's who she is. That's what she does. And none of the evidence supports anything to the contrary, and not even Mr. Harris has refuted any of that. So, in closing, we believe fundamental fairness, the charter, the letter, the notice, compels the commission to hear the evidence. I mean, what's the secret? I mean, we're in a public hearing. These voters need to know what they're electing come March and April. They should know if they're putting in somebody who wants to tear down civil service, who wants to violate the charter, who wants to put cronies in positions, who wants to create a patronage system to the detriment of city finances, public, and more importantly, these dedicated, hardworking civil servants of the city of St. Louis.
Mr. Harris, you wish to respond?
Sure. That last part was the tell. That was the tell for all of this madness about political motivation. Wanting to put this stuff in front of the voters. Wanting to air some, what they consider as dirty laundry for the public, for the voters, as a way to, if she's going down, then she wants to take the mayor down with her. That's really what's going on. It's about the voters and the public. There's an election coming up. That's the tale. The only on-point legal authorities that anybody has cited in this case were the Stubblefield case and the Roorda case. Those two fact patterns are what we have here. Those fact patterns show employees who were caught doing, bad things. They were called to account. They were disciplined. Then they alleged that their employers, the folks who were disciplining them, were out to get them. In the case of Roorda, he said the chief of police doesn't like me. In the case of Stubblefield, he said the director of public safety, this is a political fallout from what happened when the inmates escaped. And in this case, it's something about the mayor's view of the independence or not of the civil service system versus the director of personnel's view of the civil service system. It's all the same thing. What do we do with Stubblefield and Rorta? What do we do with those cases? Ignore them? What about the credit card policy violations that we put forth evidence of, that the director committed? Those happened, and she wasn't disciplined for them. She wasn't given a pre-termination notice. She wasn't, targeted because of policy differences. Let me try to put it in, in the simplest terms we can. I mean, what if she stole $100,000 from the city treasury on July the 3rd? What if she did it? What if she stole $1 million from the city treasury on July the 3rd and got caught and then was called to account, was disciplined, was tried, she was given a pre-termination notice saying you committed malfeasance because you stole this money, and we have evidence of it. You mean to tell me that if she comes in here and says, well, this is all political, the mayor's out to get me, she disagrees with how I think about the civil service system, she disagrees with me because of all of these reasons. You mean to tell me if she comes in here and says that, well, I guess, the game is over. The mayor is then out of luck because even though she stole all of this money, because they say this is politically motivated, there's nothing she can do about it. I mean, that's really what they're saying. I mean, if you take it to its logical extension, that's what they're saying. That whatever malfeasance, whatever evidence that we bring in that she committed malfeasance, and if it's strong, even if it's strong evidence, if they just suggest that it's politically motivated, well, we got to drag everybody in here and examine them. Isn't this politically motivated? Don't you dislike her because she said that, she wants to protect the workers and you want to sweep them up under the mayor's umbrella? Isn't that the truth? And we got to haul in all of these different people because the truth of the matter is it's a simple fact that she committed malfeasance when she commandeered a vehicle through a subordinate, had him drive her to Jefferson City because not because of she was trying to retrieve some papers. She's the only one that says that. Nobody else says that. And so I guess we ought to take the word of the one who has a motivation to kind of make that up. She went on this trip, this escapade, because she thought that her husband was doing something that she didn't like, okay? And even if she's wrong about that, that's not the point. The point is that because she thought that and then set about this chain of crazy events with her subordinate, going on this trip to Jefferson City, on this spy mission, and then on the way back, racing to get back to St. Louis to beat her husband back, and then having him drive her all over to the casino, playing this recording of her husband expressing his displeasure about the trip and saying some not so nice things about her subordinate. That's why we're here. Not because of some convoluted, elusive idea of, political differences with the mayor. I mean, we're here because the highest ranking human resources official in the city of St. Louis did what she did, putting a subordinate in, yes, a precarious position, and he thought an unsafe position. And then after that, engaged in shenanigans to try to, like, get out of this mess by manipulating him and Bianca Lambert. She's secretly recording him. She's asking Bianca to talk to her husband. I mean, those are the facts. That's the evidence. That's what the witnesses testified to. But they want to just wipe all of that out. They want you to stop focusing on your charge, which is to determine whether or not you believe that what she did rises to the level of malfeasance. Wipe all that stuff out. Don't think about that. There's an election coming. And, you know, the mayor is up for election. So let's haul her in, you know, so that the public can get a view of me cross-examining her. And according to what he uses, her cronies, he says. I mean, that's what this is. This is their effort to, if she's going down, she's going to try to bring everybody else down with her. I implore you to seriously consider what your charter mandated mission is under Article 18, which says, again, that the commission will make a determination as to whether or not what the director engaged in rises to the level of malfeasance, and they make a recommendation to the mayor. That's what this case is about.
If I may briefly, in 2 minutes, 3 minutes or less, just point out two things. First of all, if we were dealing with $100,000 theft, which of course is intentional, and nobody's presented any evidence to suggest that she knew she was in violation of that policy, okay, that's the evidence. They have the burden here. They haven't presented one witness. He gets up again, talks about she went to catch her husband, you know, doing something. No evidence of that. The only thing we have are the two people who were in the car. We have her testimony. She testified to it. They don't have anybody to the contrary. We have Dr. Bird's testimony, who said, I don't know why she went down there. She knows why, and they're trying to fabricate intention based on no evidence. That's their burden. If she was accused of stealing $100,000, I'll tell you what, I would personally bring the sword in here for her to fall up on. But that didn't happen. That's a gross exaggeration. She made a mistake. She admitted her mistake. She paid for her mistake. The honorable thing to do. Nobody's coming here and attacked her character. And you've seen it. You've worked with her. That's the whole thing, is you know her character. You've seen her fight to make sure that the system runs the way it was designed to run, which is fairness to the employees who have devoted their lives and careers to civil service in the city, as has she. So he can try to inflate everything for what it is, but the evidence shows that a mistake was made and recompense was made. And that should have been the end of it in the real world. So it falls on you to say, well, why are we here? Why are we paying thousands and thousands and thousands of dollars for this? He never said, Dr. Bird, and maybe we'll call him. I mean, he's still on the subpoena. Maybe we'll call him. I want to see if he felt the evidence is going to be that he hung out with their family. He invited the Reverend out to dinner to meet and talk. He's been at family gatherings. Fearful? All of a sudden now he's afraid? This is fabrication. This is fallacy. And it's all prompted by the person who is responsible, who should be sitting in that chair and offering an explanation to the public. Push the election aside. She has a duty to the public to explain her actions. She has a duty to those 45 to 5,000 employees who slave away for the city. Elections come and go, but those civil servants are the rock of this city. She owes an explanation to them as to why she's trying to get rid of her for $170.30. She has an explanation to them to explain why she snubbed her after she came out against the mayor, why she sought to publicly embarrass her during Christmas time of all seasons, seasons of joy, seasons of love. And she parades around the room and gives everybody a gift personally to embarrass her. What kind of leader is that? She earned the right to that token gift that I'm sure the city paid for. But it was designed to humiliate her. That is evidence you can decide. It is evidence to decide, what are we here for? What is the true motive? Violating city vehicle use policy is not malfeasance. Because if it was, they'd be trying to fill a lot more positions over there in the personnel department up the hall, right? We got evidence of various violations. He said, well, that's irrelevant. That's selective enforcement. No, it's not selective enforcement. Because in determining, is this malfeasance, you have to look at it in context of what has the city treated this violation as. Is this akin to jaywalking, or is this murder in the first? That's what you have to decide. And what we're suggesting is that it might be less than jaywalking because nobody's even got a parking ticket for violating the city policy, the vehicle use policy. So why, pray tell, is it now a firing offense? No, it's more than a firing offense. It's at this level of malfeasance. We have to ask ourselves why. I think the why becomes apparent once we put her on the stand and once we examine her. And once she explains, she may have a legitimate motive, and you decide that credibility. The fact that she's the mayor doesn't put her above the law, doesn't put her above civil servants, doesn't put her above the charter. Mayors come and go, but civil servants are now and forever as long as we have a city here. And that's what's at issue. That's what needs to be protected. And that's why it's incumbent on you all to hear all of the evidence, not the selective evidence, but the entire picture, and then decide.
Mr. Norwood, I do have a couple of questions, but
Yes, Your Honor.
first I wanted to say earlier, and this wasn't argued here, but relates to the issues that have been talked about here. Earlier during the evidence, I think it was a couple of days ago of hearing days, you sought to offer a tape recording that showed the mayor making a statement about city employees, civil service, I think generally. And at the time, I sustained the city's objection to it as irrelevant. You then made the offer of proof. We allowed you to play it. In reviewing your offer of proof, along with the submissions that have been submitted, I'm going to revisit that and reverse that decision. That tape is admitted into evidence. Now, the commissioners heard the tape as the offer of proof, so it's already in evidence. We don't need to replay it.
Yes, thank you, Your Honor.
All right. Now, you have, in your argument, repeatedly said there's, and I'm not clear, have you said there is evidence of cronyism?
Yes.
Or of cronies?
Yes.
What, who are they?
Well, only the mayor knows they're her cronies. That's why we need to call her. Who is this person attached, referenced here, and we're not going to state any names, but in Exhibit 41, it goes into detail about the fact that this unqualified person is sitting over there right now. He's on the mayor's political payroll, but he's sitting and warming a chair and representing and holding himself out as the new person. And they're calling her like, who is this person? And she's looking at the roles and saying, well, that position is still vacant, but the chair isn't. How does that work? This is
what position are you talking about? What agency? What?
This is a position within the Department of Public Safety and Office of Violence, and I don't want to get into it because it might reveal the name of the individual, but the Office of Violence Prevention. It's spelled out in Exhibit 41. That's attached to our motion. I'm sorry, this is a new item that if you have a copy, do we have extra copies?
We got Exhibit 41.
Yeah,
I
it's
believe
attached.
we have that, I believe.
It's attached to Exhibit 1. That's just the latest example, the brazen example. Here we're sitting in a proceeding where we're saying that this conduct in violation of the charter, because the charter, we just read it, it says it shall be merit-based, shall not be based on my whim. And when the director of personnel in advance says that person is not qualified, and therefore, under the rules, they can't sit in that seat, and without her knowledge or authorization, he's in the seat. If that ain't, and that's just within the last 2 weeks. We've got reams of other examples. We've talked about some of them here. John Understall talked about a situation involving the mayor where she's placing someone in an unqualified position. We have other witnesses who's going to testify to that. The director testified to that. We also got the Rick Frank situation where he has eligibility based upon his 18 years of service as the director of personnel. They're trying to freeze him out. Calling around to the director, understand either Sheena, a combination of Sheena and Sarah, calling out to the airport director saying, we need you to create a position for Rick Frank out at the airport. Essentially saying so that we don't have to deal with him once we get rid of her, so that we can put our crony in the director of personnel seat, where Mr. Jared Boyd is going around whispering to her subordinates, hey, we got a position for you. One of whom is under subpoena. And arguably that could constitute witness tampering, where you're offering her or that person the job when they may have to be on the stand again to talk about this evidence. I mean, that's what we're talking about. This is not rocket science. Your Honor, we've both been around the block multiple times. This is the very heart of evidence of political interference and tampering. And this is not all. There's other evidence that we intend to offer. So to say, as he suggests, that that's all irrelevant, and he's saying, oh, he's just trying to embarrass the mayor. Oh, this is all about the voters. Yes, it's about the voters.
Yes,
They should know. They should know if their appointed representative is someone who would intentionally violate the city charter. They should know that. We should know that, number one. Number two, what are they afraid of? Why are they afraid to have her come in here? If they're so confident that there's no there there, well, let's hear about the no there there that's not there.
For the record, this Exhibit 41 it looks like it's an attempt by the director to create some evidence to further support their argument. It's an email a week ago, January 27th, that the director sent that has something to do with the Office of Violence Prevention. It has nothing to do with the underlying facts of this case. I mean, is that what we're doing now? So we can just kind of send emails around and say, hey, look at this evidence. This email I just sent. This is evidence. And just attach it as an exhibit? And that's evidence of political interference? I mean...
Well, that's the latest. The email trail goes back before as early as early December.
Let me just ask, okay, was Exhibit 41 admitted?
No,
Has not been admitted.
it has not been admitted yet.
Has it been offered? It hasn't been offered yet?
We haven't presented our case yet, and we plan to offer it in our case, and I would like to show it to the mayor, and to Mr. Boyd, and to Ms. Baker.
All right, okay. So- All right, I think that then concludes the hearings on the matters that you submitted over, that we received yesterday, and I believe the commission will again go into executive session to consider how we're going to proceed here with these motions that are pending. So it is now 2:45, 3:15.
All right, I'll make a motion that we go into executive or closed session for the purpose of meeting with counsel and with our hearing officer. Is there a second?
I'll second.
Clerk, call the roll.
Chairperson Barney,
Yes,
Vice Chairperson Llewellyn.
Yes.
to 3:15.
3:15. Thank you.
We are recording. We're on the record back after recess, and again, I'm going to consider the motions that were pending that we said we would consider, have the parties submit an offer of proof. The director asked last week to submit the offer of proof, so she did submit that as one of the documents she submitted yesterday, along with her brief in opposition to the appointing authority's motion to restrict evidence of political interference. Those were the two things that the director submitted yesterday. And so that motion to limit political interference, limit evidence of political interference is before us, as well as the motion of the appointing authority to quash the subpoenas for the 4 designated officials, the mayor, the comptroller, the city councilor, and the airport director. The other 2 persons named in the motion have been dropped from the motion by the director. So first, with regard to the motion in limine to exclude evidence relating to political motivation or uneven enforcement of the vehicle policy, that motion is heard, has been heard here today, and is denied. That would be my ruling, that it's denied, that the charter provisions clearly give the right, as well as general, as I understand cases, due process provisions give the director the right to present evidence of, as it says in the charter, of political reasons. It's the language in section 7 of the city charter. So motion of the city to exclude evidence of that is denied. However, we also consider the motion to subpoena the mayor and the comptroller. I'm going to deal with those 2 first. They are both
Just
obviously
to clarify, the subpoenas have been issued and accepted, and the question is, are they going to be quashed? Just so that the record's
okay.
clear.
As I understand the law, the high public officials, such as chief executives, the mayor and the comptroller are the 2 citywide elected officials, along with the president of the Board of Aldermen. The only citywide elected officials under the city charter of the city as a city, and obviously have important duties that occupy them day to day. As I understand the law, reasons to subpoena such officials have to show a basis why their testimony would, first of all, what they would be expected to testify about, and that there's some basis for it, that it's not just speculative, and that no other employee of theirs or other person could be called instead to provide the evidence. So I do not think, and the director has filed written, a written offer of proof regarding what the mayor and comptroller, as well as the city council and airport director, would testify about. And So the mayor and the comptroller, the motion to quash their subpoenas is sustained. With regard to the city councilor, there has been some mention of the city councilor in other testimony. However, I do not believe that that has established a sufficient basis, and in the supplemental written order offers of proof that the director filed that we just received yesterday, the offer of proof with regard to the airport, the city councilor does not set forth a basis. The statement, for example, that the city councilor told Director Jenkins Gray that the mayor believed the director was attempting to sabotage her campaign. We have allowed that. That is in evidence. The director testified to that. So that's already in evidence. Likewise, there was some testimony about the city councilor communicating to the airport director, although this is a different basis, to facilitate, and the testimony on this was very vague, something about finding a place for Richard Frank. That alone does not constitute, as I understand it, political interference. The paragraph is, as has been Mr. Norwood's arguments on this, uses the word cronies to facilitate the placement of cronies. Obviously, that's a charged word, but there certainly has been no specific evidence of any so-called crony, and even what is meant by a crony. So simply insufficient basis to expect that the city councilor's testimony would achieve anything else. And then the next part is deals with the presumption of harm from conflicts of interest, which of her office, city councilor's office, well, that I think has been covered in our discussions regarding the motion to disqualify the city councilor's office that was dealt with earlier. Again, the city councilor's purported representation of Director Jenkins Gray in matters before the commission, that was discussed earlier. None of that established a basis for thinking that the city councilor would present any evidence that would be relevant here. Finally, that takes us to the airport director, and once again, the written order of proof. This is one paragraph and refers to various communications initiated by Sarah Baker. Well, Ms. Baker was a witness, could be recalled, has been questioned about this to some degree, so we haven't prevented that evidence from coming into the record. However, so far, that evidence has been insufficient to show anything that would make it worthwhile, necessary to subpoena the airport director away from her duties. Again, the city councilor and the airport director, though not as high, they're not elected officials, but they still have very substantial and important duties, and I think the law is applicable to all of them, that there has to be substantial evidence to support the necessity for calling them as witnesses. So with that is the ruling that I would make on both of those motions. The commissioners heard all of the argument on those motions. Do you want?
Yeah, I think I'll make a motion that we affirm the decisions in these issues, that they adopted the rulings of the hearing officer. Is there a second?
I second.
Clerk call roll.
Chairperson Barney,
Yes.
Vice Chairperson Llewellyn,
Yes.
motion carries.
All right, motion
Motion
carries. So those are the rulings on those two. So what that leaves us then with is, it is now 3:30. Does the director wish to present any evidence at this time?
How much time we have today? I mean,
Hour and a half, I can go to 5.
Five, hour and a half.
okay, then we'd like to proceed with evidence, and we'd like to call Ms. Sylvia Donaldson. Is she available?
I do not know. Is she here?
They're under control, so I,
Who is she, holds a position in the,
She's deputy director.
currently doing an interview of a prospective employee? All right, so is there anyone else you can call or not?
If we got maybe 5 or 10 minutes, there are other people in the interview too, I think. So if you want to go see Jeff or Jeanette.
All right, so do you, if Morris Norwood, is it all right, we just wait till they go, they're
Yes,
gonna
that's
walk
fine.
down the hall and
Yep.
check and see if she's available? We
Yep.
can stop recording, back on the record, okay? Go ahead with the witness sworn in.
Do you swear and affirm that the testimony that you are about to give is the truth and nothing but the truth?
All right, you may proceed.
thank you, Your Honor. Good afternoon. Would you state your name for the record, please?
My name is Sylvia Donaldson.
And Ms. Donaldson, where are you employed?
I'm employed by the City of St. Louis here in the Department of Personnel.
Okay, we may want to adjust the mic just a tad. There's some.
Okay.
So where are you employed?
Here in the Department of Personnel for the City of St. Louis.
How long have you been employed with the City of St. Louis?
44 years last week.
44 years.
Yep.
Congratulations.
Thank you.
And what is your current title?
Deputy Director of Personnel.
All right. And just if you could briefly walk us through some of the various positions you've had in your 44 years as an employee with the City of St. Louis.
The Department of Personnel was my third location. I started off with Slate, St. Louis Agency on Training and Employment, and worked there for less than a year before Mayor Shamo came in and probably cut about 40% of the city staff. And I wound up getting swept up in that. I eventually came back 6 months later. I worked in Slate. No. I worked in the Department of Human Services, I'm sorry. And I worked there for 12 years. Worked for the youth program and also for the senior program a little bit. So that was for 12 years there. I then promoted to the Department of Personnel in '94. I worked in talent and acquisition. It was called Human Resources at the time. And I worked there for a little bit over a year. Didn't really care for it and was allowed to transfer to the Training and Organizational Development Division. Worked there for 7 years. I was promoted to be the HR manager for the Division of Corrections, and I was there for another 7 years. There's kind of a pattern here. Every 7 years I get an itch and I have to move. So I was there in Division of Corrections for 7 years. I came back and promoted back into the Department of Personnel as HR manager for the Training and Organizational Development Division. Did that for 7 years, and then I was asked by the then director to move to Employee Relations. Did that for 7 years, and at that point, Sonia Jenkins Gray became our director, and I guess about maybe 6 or more months after she had come here, I was promoted to deputy director.
Okay. And that's your current title, Deputy Director?
It is.
Okay, and the predecessor to Director Jenkins Gray was whom?
Richard Frank.
Richard Frank. And how long was Mr. Richard Frank the Director of Personnel, if you know?
I think he was director for about 17 years. 7 of those years was before I came back to Department of Personnel, and then the rest of the time I worked under him for about
Okay.
10 years, I think.
And when were you appointed deputy?
In June of 23. Yeah, June of 2023. I think it was June.
And was that before or after Director Jenkins Gray
It
started?
was after she started.
Okay. And she would have been the one that promoted you?
Correct.
All right. And in your view, what kind of director is Director Jenkins Gray?
I jokingly tell her from time to time that I'm Team Gray because I've really appreciated the way that she has made changes in the Department of Personnel. There are a lot of things that many people who wanted to be director would not have had an idea, wouldn't have had the slightest idea of how to do it. I was very impressed by her history, her experience, not only in governmental HR, but then also literally across the globe in human resource management in a lot of different organizations and a lot of different industries. And so when she came in and was able to be really very genuine about the things that we were going to do, make some really significant changes that I don't think that any of us would have known to make, as most of us had our experience working in human services right here in the Department of Personnel. So we didn't have a vast array of information and knowledge to be able to make those changes, but she came in pretty fearless and started making some changes that did not always win the approval of department employees immediately because it was a lot and change is hard. But ultimately, we started seeing the benefit of it and the value of it, and I think the department has really benefited tremendously from her leadership.
Do you consider her a dedicated public servant?
I do. She's probably a little bit extra because she will work very early in the morning and very late at night. She has respected the fact that I don't like to work very late. I don't like to work very late at night or very early in the morning, and so she's very judicious with her time and does not call me all the time, but will respect the fact that when I'm on vacation, it is vacation. And when I'm at home, I prefer to be at home.
Okay, and is she the kind of person, based upon your 2.5 years, 2 years and some months, working as her deputy, is she the kind of person who would intentionally violate city policies?
I don't believe she is, no.
Why you say that?
I haven't seen her do that, and I've seen her be very serious about asking and seeking out information when she wants to know something, whether it's from deputies or from other leaders within the Department of Personnel or outside of the Department of Personnel, really making a point of trying to understand the whole web of policies and administrative regulations and ordinances and all of those things that kind of converge at her desk.
Okay, when you say web, could you elaborate for the commission in terms of, well, so let me strike that. You understood she came from the private sector,
Correct.
right? And you
Yes.
referred to global HR, meaning companies that do HR all over the globe.
Correct.
And you alluded to that as one of the things you found impressive about her. Could you elaborate on that?
As I mentioned before, I've been with the city 44 years. So working in human resource management for city government is the only human resource management I'm familiar with. That is also the same for most of my counterparts and most of the employees in the department. We have worked in the Department of Personnel for the city of St. Louis. So we may not have the breadth of understanding of the different possibilities and the different ways that human resource management should or could operate. And the Director Gray came in with that knowledge and with that experience, firsthand, hands-on experience on that. So she was able to kind of move the department in some areas that I doubt that many of us, had we been in that position, would have been, or any of us would have been able to do. We just didn't have that breadth of experience that she brought.
Is it fair to say she's been innovative?
Absolutely.
Tell us about that.
Part of it is the technology. I think the department worked for 5+ years trying to figure out what we were going to do, and this was prior to her coming, and then a couple of years after, or a year or so after she came, really trying to figure out how to move from pencil and paper to actually using technology in all of our major functions. And so she was able to, having worked in those areas before at various different employers, she had a familiarity with it. So it wasn't brand new to her like it was to us. So we've not only started using the Oracle and HCM and these other ones to help us to process HR functions and also payroll, but we've also moved into using the Taleo system that helps us with our applicant tracking. And we're able now to do some things that would have taken us by pen and paper, or by not necessarily pen and paper, but by the less technical areas that we have familiarity with, would have taken us a lot longer and would not have been as efficient as what she's able to bring in.
Okay, and that's a mouthful, so I want to unpack that a little bit for us lay people who don't know an Oracle from a Taleo. Mm-hmm. Could you explain to us what this Oracle innovation was as it relates to the Department of Personnel?
Well, I'm a layperson too,
Okay.
and that is not my strong suit. But Oracle is the system that we use. It processes payroll and all HR actions. It's a citywide process. So when we brought it on board for a number of years, as I mentioned before the director got here, our previous director and deputy director and other members of the staff had been working to try and configure it, what's going to work for the city of St. Louis, considering the number of operating departments we have, the number of employees that we have, the number of HR functions that we have. So it took them a long while, years literally, to start, to get that together. The director came in with a full knowledge of the systems, having worked with them before. So that put us a step ahead. So that's a big system that handles everything from scoop to nuts and all of our HR functions and also all of our finances for the city. Taleo is an applicant tracking system. So that was brought in, I think, May of last year. So it hasn't even been online for a year, but it handles all of our necessary functions for us to do the hiring of employees and tracking information. We have been in the, not necessarily pencil and paper, but using paper applications and literally paper employee files for the thousands of employees that we have with the big rolling cart that makes files roll around in circles. So we have been using that for decades and decades, and now we've been able to streamline that, and it's handled in the Taleo and the Oracle systems. So it's really just made it easier for us to do our job a lot more effectively and a lot more efficiently.
Okay, you used the word sufficient. Do you believe, in your view, is also saving the city a lot of time and money?
Absolutely.
And why do you say that?
Case in point, something that happened earlier today had nothing to do with this. I met with the TA staff, and that's one of the areas I'm responsible for, talent acquisition staff. And we have a process of hiring so many people, especially in the summer. A lot of our operating departments function heavily during the summer, the parks and recreation and forestry and those kinds of places. And normally going through the hundreds of applications that we might get for one job that is as simple as a utility worker is really tedious and time-consuming and involves a lot of the operations from one of the TA specialists. Our manager in that section has a great idea and a great grasp. He helped do the configuration for the Taleo system, was able to, for all of the main positions that we're going to be hiring for in the summer, hundreds and hundreds of applications, he was able to configure it. And I don't even think Director Gray has seen this yet, but he was able to configure it so that a TA specialist doesn't have to go reading through each of the applicants and applications and determining whether or not they're eligible to even get on the list of eligibles that go to the operating department. He was able to configure it so that the application will automatically, the system will automatically determine whether or not people are eligible without having to have the input from the HR specialist. So that's just going to save us so much time. We can be that much more agile and provide the information to the operating departments as quickly as they need.
Okay, and do you consider your director a valuable asset to the city of St. Louis?
Absolutely.
Okay. Now, as part of her, and you talked about a web and maze of policies and protocols, is it common for her to reach out to you and other subordinates to guide her as to what to do as it relates to this web that you've described?
Absolutely.
Tell us about that.
If there's a policy that she's not certain about, or she's not sure what the connection is between what, for example, something that might be included in the civil service rules and our administrative regulations, and where do they really overlap, or something that might be included in the charter and how it impacts the civil service rules and how that impacts the administrative regulations. So sometimes just looking for guidance from people who have done that for a period of time and are familiar with it is definitely necessary, and she doesn't have any qualms with reaching out to subordinate staff, whether it's line employees or it happens to be some of her management staff or either of us deputies. She doesn't have a problem with reaching out to make sure that she has good information on it.
And does she reach out to you to get advice?
Absolutely.
And that's because of the fact that having been here 44 years, you have a greater understanding of the web of operations in the city.
In a lot of areas, yes.
In a lot of areas, okay. And then there are other people that have other specialties in other areas,
Absolutely.
right? And she, despite the fact that she's the boss, she doesn't have any problem with going to those subordinates and saying, you know, how do I do this?
Not at all.
Okay. And you understand, even though you work mostly in the city, that the private sector is a little bit different than how the city operates, right?
Sure.
And would you say, is it fair to say that the city is unique in terms of how it operates as it relates to HR functions?
Absolutely.
Why
We're
do you say
probably
that?
unique from other cities as well.
Why do you say that?
Just because how we are governed and it's that kind of top-down, that really starts with the charter of the city of St. Louis, which is extremely antiquated. Every now and then it gets some upgrades. There'll be a particular area that there's a desire to change. It goes before the citizenry and they have to approve changes to the charter. And then that informs what happens with our civil service rules. And those are, in a lot of areas, they are a little antiquated. And so there's a connection. You take an older charter and you mix it in with an older civil service rule, and then you have administrative regulations that come from that. The charter clearly says the things that are the responsibility and the sole responsibility of the Director of Personnel, and then the Director of Personnel promulgates the appropriate rules and regulations that do exactly what the charter says they're supposed to do. So it's just there's a lot to it. And then that doesn't take into account the other kinds of rules that might be out there, ordinances that impact how we do what we do, and sometimes even rules that are promulgated by other operating departments that are necessary for their specific area. And so it's kind of hard to be expected to know all of those things, but there is an expectation that we in the Department of Personnel will have a really good grasp on those things, because we're going to get questions from everyone about what should I do and what's the guidance for how I should handle this.
I haven't been here 44 years. Do you know all of those rules and regulations of the city?
I have no interest in knowing all of those rules. No, I do not know all of those
Well,
rules.
when an issue pops up, what do? You try to figure out what it is,
Yeah,
right?
I try and I'll either talk to my peers, ask some questions, or I'll start looking them up as best I can. There are a lot of things that are online on the city's website, probably have been for less than 10 years, but there are a lot of things that are on the city's website that we have access to, and they are in one spot, so we can really go in there and look them up and pull those up, but that doesn't apply to everything.
But and even pulling them up, you have to kind of know what you're looking for and,
Sure.
and perform a search. Is that fair?
Yes.
Okay. And so the fact that, say, if the director didn't know about a particular policy, that wouldn't be out of the ordinary given the maze of stuff we were talking about.
No, it would not be.
All right, because you're in the same boat, 44 years and climbing, there are policies you may not have familiarity with as well.
Oh, absolutely.
All right. Now, the charter. Do you know if that charter provides protections against discipline being used for political reasons?
I can't say if it specifically says that, but it does talk about political influence in a lot of areas. I can't say that it
Okay.
specifically addresses what you said, though.
Okay, let's remove the political out of it. Is your understanding that the Department of Personnel is supposed to be independent?
Absolutely.
And what is your understanding as to what that means based upon your 44 years of experience?
My years of experience notwithstanding, the civil service rules very clearly say, and the charter very clearly says, what is the purview of the Director of Personnel solely. These are the things that person, that position is responsible for taking care of. And it doesn't say it's a good idea or maybe you want to try it. It says you shall. So there are a lot of the Director of Personnel shall do X, Y, and Z. Case in point, it says that the Director of Personnel shall develop the compensation plan. However, that has to be presented by the Civil Service Commission, but they don't create it. The
Okay.
Director of Personnel is solely responsible for making sure that it's created, and then it does go to the Civil Service Commission. They review it, and they have whatever comments or whatever they might have, and at some point, the document is ready to go to the Board of Aldermen. So it's real specific on some of the things that the Director of Personnel shall do, but then there's some connection to some other areas that impact it as well.
Okay, what about independence, though? Is the department supposed to be independent of politics, I guess?
Yes, the Department of Personnel and pretty much the rest of civil service should be independent as well.
Why? Why do you think that's the case, based
That's
upon
the
your
whole,
experience?
yeah, my understanding that that's the whole separation of a civil service system as opposed to being private sector. We are not employees at will. We are, working for the civil service system. We are government employees akin to those that are working for the state and or federal government. So it's a very similar kind of situation. And so there are protections that are built in for civil service employees that may not exist, that do not exist for at-will employees that might be working for private industry or somewhere else.
And that would apply to all civil servants, correct?
They should, yes.
Including the Director of
She
Personnel?
is a civil service employee, yes.
Okay. You familiar with the term progressive discipline?
Yes.
What is that?
The city has a progressive discipline policy, which basically says that there are some things that are so egregious and so significant that they warrant immediate dismissal. No ifs, ands, or buts. But that in order to train employees on the proper way to handle things and not to be overly, I can't think of the word that I want, not to punish people, because discipline is not necessarily intended to be punishment. Sometimes it can be corrective action to help people do better later on. So in the city system, the progressive discipline policy starts off with lower levels of discipline, and then they increase depending on whether or not the employee has successive issues where they have violated policy and or procedure. So the idea is, kind of what you do with your kids, more or less. You talk to them, you maybe give them a little punishment. They don't get to do X, Y, and Z. The next time they might get a whooping, and the next time they might just be, sent to their room and they can't participate in any of the fun stuff that they want to do for the next 2 weeks. So you just progress in the amount of discipline that is given to a person based on a violation. There are, again, some things that are significant, though.
Did you just say whooping?
Yeah, I'm old school. I believe in whoopings, yeah.
So when you talk about progressive discipline, do you take into account the performance of the individual?
You do, and actually in our Administrative Reg 117, I think it suggests, or it either suggests or it requires that you're clear if an employee is going up for a disciplinary hearing, that you tell them whether or not their previous disciplinary record is going to be considered. So that basically says we're going to look at how you've behaved in the past, and then we may need to escalate based on that. So that's generally expected in some kind of a disciplinary process.
Okay, and you focused on other discipline. What about good performance? A good worker, is that factored into the equation?
It can be factored into, it's not specifically, to my recollection, it doesn't explicitly say that. For example, in Administrative Reg 117, which is the discipline policy for civil service employees, it doesn't specifically say that, but it says an individual's prior history is going to be considered, so that would include
Good,
that.
bad, and ugly.
Should be.
Is that right?
Should be, yes.
Okay. Now, are you familiar with the city's vehicle use policy?
I am.
And are you aware, since you've been employed with the city, of situations where people have used city vehicles for personal purposes?
I have heard of some situations, yes.
Okay. And are you aware of situations where an individual has been disciplined in any form for violation of that policy?
I'm not personally aware of any, no.
Okay. In 44 years?
44 years.
Okay. And would you know why?
I don't know that they weren't. I'm saying I'm not aware of any instances
Okay.
where someone may have been.
And you've been around, and people talk, and there's a lot of stuff. In fact, there's reported stuff floating around out there, too,
Sure.
regarding personal vehicle use, right? Mm-hmm. Is that a yes?
Yes.
And over your 44 years, you've seen stories come out about personal vehicle usage and things of that sort, correct?
Yes.
Like, for instance, there was a story about the recorder of deeds and her husband driving a personal vehicle. Do you recall seeing that one?
I've heard that recently. I don't know how it came up, but
Okay.
I have heard that recently.
I want to object. I think he's asking for hearsay. It's getting
Well, I
into
withdraw the
calls
question.
for hearsay.
She said she didn't know. I'll withdraw the question. Are you aware of anybody being terminated for violation of the vehicle use policy?
No,
All right. In 44 years, you haven't heard anything about anybody being terminated for
I have
violation of
not.
policy? Okay. Now, in your capacity as deputy director, do you often sit in on civil service commission hearings?
I do a lot less frequently than I used to, simply because the Director of Personnel is the secretary to the commission, and so she will sit in on most of them. There will be instances where she may ask me to be absent and ask me to sit in her stead, or to sit in if there's something else that I need to be aware of that she is also there for.
Okay. Let me go to back a little bit at a time when Mr. Frank was the director of personnel, and he then ultimately resigned, correct? Retired, okay. And are you familiar with a time when it was a situation where locks were changed in the department?
Yes.
Tell us about that.
When the Director of Personnel retired, the previous civil service rule required that the Civil Service Commission make an appointment of someone in the Department of Personnel to be the interim until such time that there is a list that will go to the mayor's office for her selection. And during that time, the Civil Service Commission appointed me to serve as the interim director. I think I had just started I don't even know if it had been a week, and I got a call from Nancy Cross, Director of Operations for the current administration.
You mean the mayor?
For the mayor, correct.
Okay.
She called me at home on a weekend and said that she had received some information that the previous director, Director Frank, and his deputy someone had reported to her that they had been in their office shredding a lot of documents. She asked me about it, and I said, I work on the other end of the hall. I know nothing about it. I had no familiarity with it. But as the interim, she asked me if I could find out if that were the case, and if I could find out, they had mentioned that we use big roll carts that go to ProShred when they come, I think it's ProShred, when they come and pick up our shredding. And would I look for that to see if that basket was still there? And I did she may have called me prior to the weekend then, because I did look, and there was still a roll cart that was in that area. On the weekend, they decided,
Who was the they?
Nancy Cross and whomever else she had to deal with, or it could have been her independent decision, I don't know. But she called and let me know that they were locking the rooms where the director had been, and right in that same area, there was the room where the deputy director had been, and there were another couple of small offices that were over there, and that they were locking it, and they were going to change the locks. And first thing on Monday morning, they were going to try and come over and make sure that everybody knew what was going on. So she explained to me what her concerns were, and that she would be here first thing on Monday morning. So I got here early on Monday morning. There were already some employees that were here who had their offices in that area, and they found that the doors were locked. So everybody was kind of up in arms because they didn't know what was going on. And at some point, I think Ms. Cross contacted me, and I was able to give them the information that I had. And they wound up, I think it took at least 2 days, I want to say, before they finally had somebody to come in, and they were satisfied with what was going on, and they could let them back into their offices.
Who had the keys during that spell?
Nancy Cross would have had the new keys. They may have had them rekeyed so that the staff could not use their current keys to get into the office. I did not have a key initially. Eventually, when I did, contact, or when Ms. Cross contacted me again, I did get a key. The locks were eventually changed, but it took, as I said, a couple of days. And during that period of time, those employees that worked in that area were unable to get into their workspaces. I think one person could, because she was attached to another office, so she could get in and get to her stuff. But for the most part, they were just locked out because there was suspicion that something was being shredded, and they didn't know what it was. I was also directed, once we could get in the room, if I could find the roll cart, that I was to put the roll cart in my office and secure it and keep it until they decided what they wanted to do in Ms. Cross's office.
So folks were just wandering the halls for 2 days?
I think they really all sat in one room just to be on the safe side, but they couldn't do much because they couldn't get to their offices.
So, but the mayor would have had access, and her staff would have had access to those.
I know Nancy Cross had access. I don't know whom else may have had access. I know Ms. Cross did.
Okay. All right. Now, were you made aware by either Mr. Boyd or Ms. Baker regarding concerns they had about Dr. Byrd and his use of a vehicle over the 4th of July weekend of 2024?
They did have conversations with me regarding that.
And tell us about those. In late July,
maybe the last weekend in line, or the last Friday in July, Director Gray became ill and called the paramedics. There were several of us that happened to be in the office at the time. We called the paramedics, waited for them to come to see what was going on. She was having palpitations and really not looking well and not doing well. We called 911. The sheriffs came from downstairs because they wanted to check and see if everything was okay. And they came up, and bottom line was the director went out on family medical leave and appointed me to be acting in her stead. So she was gone, I was the acting director. There's a process of the director having regular weekly meetings at that time with Jared and Sarah in their office, or they would be virtual or something. And since I was the acting director, then I had to take over those. And it was during that time that I was asked by, I'm pretty sure it was Jared. The meeting would have been the three of us, and I'm pretty sure it was Jared. He mentioned at that meeting that he had spoken to Dr. Byrd. Dr. Byrd had told him whatever his recollection of the events was, and that he had given him that information, and that he had also played for him, or had shown him, or had played for him voicemails that happened on that same day. So he was familiar with that, or messages that were left on Dr. Byrd's phone. So he had that information. But what he asked me in the meeting was if I could direct Anthony to put the information in writing, again, his recollection of what took place on that day, and if he could also give them a copy of the messages. They went to the city councilor, Sheena Hamilton, and she penned something. She wrote out something, this is what should go out, this is how it should request the information. And so I didn't make any changes to it, and that's how I prepared it, and I gave it to Anthony Byrd. He and I talked about it, and I said, I don't know that there's necessarily a problem. They said that you've had this conversation with them, they want you to document it, and also that you actually read the messages to them. They just want a copy of the messages that you read, because they didn't write them down. And that was what the request was, to get that information and to provide it to Jared Boyd. I indicated to him, because I wanted to know as little as possible about the whole situation. It didn't involve me. I indicated to him that once he did the response, to put it in an envelope and to seal it and to give it back to me, and I would personally hand it to Mr. Boyd when we got back to his office.
So you were directed essentially as the, at least at that time, the acting appointing authority.
Correct.
To direct him to take certain actions at their request?
Yes.
Okay. And did they ever provide you with a vehicle log of any sort?
No.
Did they ever point out any discrepancies in that vehicle log?
We didn't discuss anything about any vehicles.
I'm sorry?
We didn't discuss anything about any vehicles.
Okay.
Just wanted to know what happened and what he had also
Okay.
shared
So
with
if there
them.
was information on those logs, neither Mr. Boyd nor Ms. Baker brought it to your attention?
No, no one
Right.
brought it to my attention.
And if there was something amiss about the information recorded on those logs, would they have had an obligation to tell you about that?
I don't know. I don't know if they would have been obliged. I think what they asked me for was for Anthony to recapture the conversation he had had with them, because for whatever reason they didn't take notes. To
Okay.
recapture that information, and then also to provide them with the voicemails.
In any of the discussions you had with either Ms. Baker or Mr. Boyd, did the issue of Rick Frank come up
In relation to this instance,
in relationship to anything as it relates to Mr. Frank?
actually it did come up. I was told that there had been a request to go back on the reemployment list that was made by former Director Frank, and that they wanted, I don't know who mentioned it, I don't remember if it was Sarah or Jared, I really don't remember, but it came up that they wanted him to fill a position at the airport.
Okay.
Program manager or something on that order, I can't remember exactly, but a position at the airport. And I balked at it because that's not what he was on the reemployment list for. He was
Okay.
on the reemployment list for Director of Personnel.
Okay.
So that's the list he goes back on. We don't just find a list to put him on. He goes back on the list that he has reemployment rights to.
Did you find that odd?
Yeah, it was unusual, and it's not really what the process is. They go back on the list that they are to be, the reemployment list that they've asked to go back on, that they were on.
Well,
That
do
was
you
a
know why they
position
were
he
trying
held.
to ship him out to the airport, though?
I have no idea.
Okay. And reemployment list, those are rights that a former employee has to at least be in strong consideration for that position if they decide to come back, correct?
Correct.
And do you know if the reason they were trying to ship him out to the airport is that they didn't want him to be Director of Personnel again if, for whatever reason, the Director, Jenkins Gray, was no longer in the position? Do you know that?
I have no idea.
Okay. But it was unusual, in your view?
Correct. It wasn't appropriate. That's not how a reemployment list works.
When you say not appropriate, meaning what?
That's not how a reemployment list works. When I leave the city, if I want to come back as reemployment, I can come back as a if there's a vacant for a deputy director, I promise you I won't be doing that. But if I wanted to do that, that's the position I would come back for.
And you talked about those rules. There are rules that govern that,
How
correct?
the reemployment list works, yes.
And to the extent that you had agreed to somehow ship him or somehow help him get out at the airport, you would have been in violation of those rules, right?
Sure.
And you didn't do it because you didn't want to violate those rules, right?
That's not what I do. I don't.
And you explained to them the rules, right?
I can't remember. I just remember telling them, no, that's not the way it works. He has to go back on the list that he's on. He has to be put in that position.
Okay, all right. Are you aware of any other sort of strange incidents like that where individuals from the mayor's office sort of sought to work around those civil service rules and charter rules regarding merit-based placement?
One of the incidents that I do recall, and it wasn't really so much in terms of placement, but at the time, the former Commissioner of Corrections, Jennifer Clemens Abdullah, she was on leave of absence while she was on family medical leave. I had been involved in conversations and communications between Director Coyle, who would be her immediate supervisor, her appointing authority, and I believe Sarah Baker was involved at that. Even though she and I did not talk, she penned some things that I took a look at. So she was involved in writing something that I took a look at. And what I was asked to do, I was asked to do.
I'm sorry,
I'm
Ms.
sorry.
Thompson, to interrupt you, but can you explain what exactly do you mean when you say penned something?
She wrote something. There was a statement.
Penned as in wrote it?
As in wrote.
Oh,
As in
okay.
wrote. Okay. She had written something
That's okay.
that I
No.
needed to review, and I did review it. So there were two things that were kind of connected to that. One of them was that Chief Coyle, Director Coyle, was in the process of looking for what my understanding was for a position for Commissioner Abdullah to land in. And the position that they had looked at was the Commissioner of Towing. Well, Commissioner of Towing is not a position that belongs to the Director of Public Safety. Towing is not a part of public safety. So it was odd that he would ask for that. And I understand during my conversation with him and information that he also shared that it wasn't his suggestion, it wasn't his idea, but they were looking for a place for Jennifer Clemens Abdullah to land. Now, they didn't say it meant when she terminated, and it could have been that they wanted to demote her and put her in another position. But I was asked, well, if we do that, you're the only person who can increase the maximum starting salary. We need an increase of about 40%. And I said, yeah, I might be the only one who can do it, but I'm not doing that. I have no reason to do that.
Well, who was asking you to do that?
Chief Coyle, Director Coyle mentioned that, but he doesn't, that's not his department, so he would not have thought that I could make a decision for him in another appointing authority's department. I wouldn't think he would have thought that. Somewhat connected to that, a later conversation that I had with Jared and Sarah during one of the weekly meetings revolved around finding a place for Jennifer Clemens Abdullah to land after she was terminated. Now, mind you, she hadn't had a pre-termination review at all. But after she was terminated, where she was going, how she was going to land. And I was asked at that time if I would take a look at a resume of a person that they wanted to replace her with. And I told Jared, I don't have an action in front of me. There's no actionable item for me to look at. I have no interest in looking at somebody's interview. And I made it real clear that Jennifer Clemens, like any other civil service employee, would have the right to due process. And that means she has a pre-termination hearing, at which point she and/or a representative that comes along with her get a chance to talk about what the mitigating circumstances may have been around the situation, or give what other kind of information that they wanted to share. So I told them I don't have any reason to look at I don't have a vacant position to even look at. I was then asked, they had the resume, and I was asked if I would look at something else. If I wanted to, I can't remember what it was, but they wanted me to pretty much look at a person to replace Jennifer even though Jennifer was still on the payroll and still had not a pre-termination hearing. I said, I have no reason to do that. I have no actionable item in front of me that I need to either make another decision or look at anybody's information or decide that I'm going to increase any. I have no reason to do any of those things.
And that would
I
be a-
refuse to do it.
That would be a violation of the civil service rules as well, right?
There's nothing to, it's just, it would be a violation of the disciplinary action because Jennifer was still an employee. I don't need to look for a reason to replace her because until she has her due process and actually has her pre-termination hearing, she's still on the payroll. I don't need to look to replace her, and I don't need to look to increase the maximum salary of any position to put anybody in. Those are things I don't have to do, and I refuse to do them.
Okay, and did you find that problematic?
Yeah, it was inappropriate to me because whether or not a person is, there's some things that are so egregious that they warrant termination, and there's a process, there's a whole list and a lot of stuff that has been provided in our Administrative Regulation 117, kind of give some ideas. But those were not the things that happened. So there was no reason for me to likely assume that Jennifer Clemens Abdullah was going to be terminated with her preterm. She had due process. She may have had great reasons for the things they charged her for. We wouldn't know about it until she had her hearing.
And that hadn't happened yet?
It had not happened, no. She
Yet
was still on family medical leave.
So she was on family medical leave.
Yes.
She was still in the position, and Jared and Sarah are working you over in order to fill a position with somebody before anything has happened as
They
relates
were
to-
asking questions. I won't say that I was worked over.
mischaracterizes
Say they
the
were
testimony.
asking
Okay, well, let me
questions.
rephrase
We've
the
got three
question.
people talking at once. I doubt seriously that any of what was just said by any of the three got into the record.
I will
So
withdraw the question and ask it
questions
another way.
withdrawn, so that wipes it out, and we don't need to worry about
I
it.
think we're well beyond the limit for direct examination. We're
Oh,
at
where-
35 plus
Where were
40
you?
minutes. So we started at 3:36.
And that puts us at, well, we'll stand down for now. And we have 20 minutes for redirect. Thank you.
I'm sorry, may I take a restroom break?
Yes, certainly, go right ahead.
Thank you.
36, I believe we're about 5 minutes past the 35 minutes, right? Thank you. He gets same 35. So that'll take us to 5. If he uses it. Unless he doesn't use it a whole lot of time.
Here, I got an extra one.
Okay, and we're coming back,
And I won't mark this on your
coming
meeting.
back Monday at 10? Coming back Monday at 10?
I think so.
Yeah,
I think so too. Yeah, I have 10, and
It's
I have
10:30 is on the 11th.
Tuesday.
Yeah.
Tuesday is 10:30, because you have a meeting you
That's
have to catch before, yeah,
Yeah.
I got that.
All right, witnesses back, everyone else ready? All right, Mr. Harris, you ready to do cross-examination? You have the same time, 35 minutes?
Your Honor, I may not have.
Not going to use that
I may
much.
not have any cross at all.
Well, if you
Um,
don't,
So
that's it.
Yeah, I mean, I assume that means there's no redirect if there's no cross.
There's no redirect if there's no cross.
No questions. for the witness.
No questions, no questions, Ms. Donaldson.
All righty.
You're excused.
Thank you very
and-
much.
You're welcome.
And thank you for your 44 years of service to the citizens of the city.
Okay, we'd like to
Okay.
recall Mr. Jared Boyd.
Okay.
See if he's around.
Or Sarah Baker, I mean, whoever's.
Is either one of them around?
Maybe we take a few
Sure,
minutes to see if we.
sure.
Yeah.
Turn-
thank you.
We'll stop recording till we have a witness available. It's 4:29 with the same time. If my math is right, that'd take us to 35 minutes, it'd take us to 5:04.
Okay.
So we certainly intend to adjourn it at 5, but we'd go that extra minutes if that's, you need that amount of time. Now,
Yes.
Mr. Boyd, you are still under oath, having been sworn in when you were previously on the witness stand, so you may proceed.
Thank you, Your Honor. Could you pull out the thick binder and turn it to tab 35? Okay, now, I believe when you testified in the appointing authorities case, you talked about the fact that you scheduled this public hearing through communications with the commission. Is that correct?
I testified to trying to work with the former chair to schedule a hearing. That's correct.
Okay, trying to work with the former chair. And I believe you testified that there was never any firm date provided with respect to that hearing, right?
I stated that I worked with him to try and find a date that he and his other commissioners were available.
Okay, let me unpack that. You worked with the former chair, Dean Perry Dibo, correct?
I reached out to him to try and to work with him to check his availability for a hearing date.
Right, so you tried to schedule a hearing by working through Dean Perry Dibo, correct?
I worked, like I said, to try and find availability for him and to see if he could help facilitate scheduling a meeting with his other commissioners.
And did he do that?
He said that was trying to recall, but I do recall him saying that date, the date that on or around September 3rd was available for him, and that's what I recall.
Okay, so he was available. What about the other commissioners?
He was chair of the commission, so I'm trying to recall the details right now, but I know that I checked with him and, like I said, tried to work with him to facilitate a hearing date.
Okay, let's take a look at Respondent's Exhibit 35, which is an email that appears from Commissioner Fluellen dated Wednesday, August 28, 2024 at 9:26 a.m. And take a moment to look at it, if you could, and I'm going to ask you some questions about it.
Okay.
Okay, and from the email, it appears that Commissioner Flewellen doesn't know anything about anything as it relates to the Director of Personnel. Isn't that what's suggested in the communication?
It suggested, I guess, that he was not provided with information from the Personnel Department on the director status.
Well, it says, let's take a look at it. It says, I hope this email finds you well. I'm writing to formally request information regarding the recent news about Sonia Gray, the Director of Personnel. He says, I was both surprised and disappointed to learn of Mrs. Gray's leave through the St. Louis Post-Dispatch. He says, to date, I have not received any official communication from the Office of Personnel regarding this matter, despite my recent text message. You see that?
Okay.
Right? That's what he said, right? Right? And then he says, in the second paragraph, I find it somewhat unacceptable that commissioners remain in the dark about the situation. You see that?
Okay.
You see that?
That's what's written here.
Okay. And then it says, if I am the only commissioner who has not been informed, that raises additional concerns and issues which also demand attention. Do you see that?
Yes.
Either way, it is unacceptable to be left uninformed in this manner. You see that?
Okay.
You see that, right? Is that a yes?
Yes.
Okay. Do you know when Commissioner Flewellen found out about these charges that were being lodged against the Director of Personnel?
I don't recall the when or how he gained knowledge of the charges against Ms. Gray.
Well, did you communicate, when did you communicate those charges to the commission?
I can't recall when I communicated the charges to the commission. I do recall, as I stated earlier, letting the former chair know that there was a unique circumstance with respect to the pre-termination proceedings because they're governed by a very unique process that required a hearing date.
And when did you communicate that to the former chair?
That would have been sometime in August, I believe.
Okay. And so to answer my question, though, isn't there a process to notify the commission about charges against an individual?
Well, my attempts were based upon finding a hearing date.
Okay. So beyond, well, I guess my question, maybe I'm sorry, it's been a long day. When did you formally notify the commission about the charges against the Director of Personnel?
I would have to go back and look at notes, but I think, I don't know if it was the notice that was sent to her. I can't recall the manner in which the commission was notified of the hearing. It's a unique instance in which the commission itself typically is the one that schedules hearings, but given the fact that the folks that schedule the hearings were actually implicated, and to the fact that the director was actually also implicated, this made for a unique circumstance.
Okay. So as you sit here today, you don't know when the commission was notified, correct?
As I stated before, I can't remember the method and manner in which they were formally notified of the charges.
Wouldn't there be a record of that? I mean, this is an important thing. Wouldn't there be an email transmission or something that would show how and when it was communicated to the commission?
Perhaps so, but like I said, I can't recall at this point in time the method and manner in which they received notice of these charges.
Who would have been responsible for communicating that to the commission from your office?
As I stated before, like I said, I don't know if it was an email, but
Well, that wasn't my question, sir.
Okay.
Who was responsible? Was it you? Was it Sarah? Who was it? Who had the responsibility to notify the commission?
the responsibility to notify the commission of a potential hearing date, or what are you asking?
Of a hearing date, of charges. Let's just start with charges. Whose responsibility was it to notify the commission of these charges that have been levied against the Director of Personnel?
I guess they were provided notice through a letter of the charges. I think that's what occurred in this case, if I'm not mistaken.
Sir, I'm sorry. Maybe it's a long day for both of us. who in your office, you are the ones who prepared the charges, right? Can we start with that?
Can I just object? I mean, why are we going over ground that you could have gone over back when you testified before? There's nothing new here.
Well, whether we could have gone over it before isn't the issue. That was in your case,
Okay,
you called him as a witness.
I'll object to relevance then.
Right. And the objection is relevance as to how the commission was provided notice of the charges.
Yes.
All right. Overrule.
Who? I'm just trying to figure out the person. Is it you or is it Sarah?
I think, like I said, that a letter was provided to the commission as to the charges, or
By whom?
essentially,
By whom? Who provided the letter?
I trying to recall how the commission received notice of the charges, but I think they received a copy of the pre-termination letter at some point in time.
At some point in time. Do you know when that point in time may have been?
Like I said, I can't recall the exact manner and method in which the commission was notified of the charges.
You all were the investigators, right?
As the appointing authority, we were charged with the investigation. That's
Okay.
correct.
And as the investigator, you're responsible for maintaining the materials associated with the investigation, right?
We, like I said, conducted an investigation and provided notice of those findings.
That
And
wasn't my question,
Sure.
sir. Okay. As the investigator, there should be a file, an investigative file, right?
we do have, I guess, documents that have been turned over that have been relevant to this investigation.
Okay. And in those documents, is there a document that shows when it was communicated to the commission?
Objection.
To your knowledge.
Asked and answered.
Sustain.
To your knowledge.
He said he doesn't know. He's repeatedly, you've asked him.
No, the question was whether or not there is a document in a file. He says he doesn't know. I'm trying to see if there's a source document that we can reference.
Same objection.
Well, I'm not sure the witness answered the specific question of, do you know whether there's a document in a file? Isn't that the question?
Yes.
You understand the question?
To the extent that we have investigative documents, they were documents that were collected in efforts to make a decision regarding pre-termination. So the investigative notes, I can't recall, like I said, the notes that I'm most familiar with relate to the information we gathered in making a pre-termination recommendation.
Fair enough. Let's take a look at Exhibit 41. Did we have that one?
I do not. I have goes up to 40.
What is this, 41?
Yes.
You're asking him about 41?
Yes.
Okay. We all have 41 here.
Yes. Now, you've seen this document before, I take it?
Yes.
Okay. And what is the document?
It's an email from Director Gray to the Public Safety Director.
And you were copied on that letter, correct?
Correct.
And prior to this, you had communications with Director Sonia Jenkins Gray about this particular issue, correct?
I'm trying to recall if I had direct conversations with her on this or if Sarah Baker did.
Okay, let me hand you, do we have copies for?
We do. I just need to mark them.
Okay. All right. So what do you recall about any conversations with anybody about this issue, the issues reflected in this urgent charter compliance concern?
Let me object to the relevance of this exhibit, which has not been admitted in evidence, even though he's projecting it on the screen.
Well, we can take it down for now.
The relevance of this exhibit
We can
to
take it down for now.
anything.
All right. Your response, Mr. Norwood, as to the relevance of this exhibit, what issue is it relevant to?
It's relevant to political interference in that the letter the email makes clear that the director, who will ultimately perhaps testify about the communication, brought to their attention concerns, serious concerns about an attempt to place an employee in the Office of Violence Prevention, which relates to political interference, which this tribunal said is relevant to the query with respect to our defense, and overruling their objection to political interference evidence.
All right.
Political interference as it relates to the director in this case, not just political interference in general
All right.
as to anything.
All right. The objection's overruled.
Okay, so what's going on here?
Email says charter compliance concerns OVP.
OVP meaning the Office of Violence Prevention, right?
That's correct.
And she was raising concerns about you, about efforts from your office to place an individual in the Office of Violence Prevention, right?
Place as in place on the payroll of the Office of Violence Prevention.
Yeah.
Well, the person that she's concerned about continues to work in the mayor's office. So
Okay. Do you know if that individual is camped out over in the Office of Violence Prevention?
camped out, no. I think this person, like I said, continues to work in the mayor's office but provide assistance to the Office of Violence Prevention.
Okay. And do you know if that individual is holding himself out as being part of the personnel staff of the Office of Violence Prevention?
The person is not holding themselves out to direct the Office of Violence Prevention. They continue to work in the mayor's office while also providing assistance as the Office of Violence Prevention is looking for an interim director, but that person still works in the mayor's office.
And who placed him over there?
Placed him over there.
In the Office of Violence Prevention, which is what we're talking about, Mr. Boyd.
Sure. This person, like I said, is helping the Office of Violence Prevention while they also maintain their job in the mayor's office, but they are not acting or holding themselves out to be a director.
Okay, but she raised concerns about it from her vantage point as Director of Personnel, correct?
That's what it appears, yes.
Okay, and you received a copy of this email, right?
Yes.
I'd like to move for the admission of Respondents Exhibit 41.
Objection, same reasons. It's irrelevant to political interference as it relates to the director's conduct in this process.
All right. With the one question you have, and I understand trying to protect the privacy of individuals, you have blacked out the actual name of the person, correct?
Yes.
Is it the same one, all three places where a name is blacked out? Yes, it is. Okay, so that all refers to this same person that you've been asking
Yes,
about?
yes.
All right, I'm going to overrule the objection, admit Exhibit 41.
Okay, let's look at the email to you, along with others. And in the email, it says, she says, a new matter regarding the Office of Violence Prevention requires immediate attention and correction. You see that?
Okay.
First sentence.
Okay.
Okay, you see that?
Okay.
Is that a yes?
I see it.
All right. And you saw it when you read it, right?
Yes.
All right. And then she says, although during our conversation you stated that blank is located at OVP office and is primarily providing documents to you for signature, he is physically in the office 2 to 3 days a week, and 3 reliable sources confirm that he is recognized as the acting commissioner. Do you see that?
Okay.
You
Yes.
see that? You see that?
Yes.
And she communicated that to you, right?
Yes.
And did you respond and tell her, oh, no, that's not accurate?
The email was actually directed to Director Coyle. So
Well, you were copied on it, right?
yes, it says Director Coyle in the top.
And he, this person who's blacked out, was on the mayor's staff, as you just testified, right?
Is on the mayor's staff.
Oh, that's right. Still is on the mayor's staff, right?
That's correct.
So that was the mayor's employee over here at OVP, right?
The mayor, as I stated before, yes.
Okay. And she says that this is in the fourth paragraph. This is particularly concerning, as several weeks ago I was contacted about blank serving as acting commissioner, and I explicitly informed everyone that he does not meet the minimum qualifications for this role, right?
Which paragraph?
The fourth paragraph.
Okay.
That's what it says, right?
I'm sorry, say that one more time?
Well, could you read it to yourself,
Okay.
that fourth paragraph?
Sure.
Okay. All right, so you see that, right?
Okay.
And that's what she communicated to various people, including you.
Okay. As stated, this person was not placed on the payroll for the Office of Violence Prevention, so
Okay. Did you, but she says that she informed everyone that he didn't meet the minimum qualifications for the role, right?
okay.
Yes?
And accordingly, that person was not transferred to that position.
So what was he done in conjunction with the position?
The position remains open.
Okay, and he's over there doing what? I'm sorry.
Providing assistance, like I said, in the interim.
Does he have qualifications as it relates to violence prevention?
Yes.
What are those qualifications?
Let me object. I mean, we are going far afield on this matter. I don't understand why we're.
Sustained. I think the relevance, as you say, is we're afield.
Okay. In the fifth paragraph, she, meaning the director, cites Article 18, Section 3A of the Charter, which talks about the prohibition against anyone being employed or paid in a position unless it is determined that the person falls within the position by appropriate class, correct?
So it states that, but the person is not employed or paid for that position.
Well, it says, further, the current arrangement of having a mayoral appointee perform work in a support role for OPV due to the commissioner vacancy violates the charter provision, is what she says, in her view, right?
I don't understand how that follows.
Okay, did you respond to her and say you're all wet on your reading of that charter provision?
Like I said, I don't understand how that follows.
That was my question, sir. Did you respond, since you were copied, and advise your director of personnel that that was inaccurate?
I did not, because it stated before this email was directed to Director Coyle.
So you ignored it, even though in your mind, in your view, everything was copacetic, right?
No, I spoke, like I said, I did not respond to her directly because it was not directed to me directly.
Okay, so you just ignored it.
I did not ignore it. I read the email.
Okay, after you read it, you ignored it.
No, like I said, I looked at the situation and didn't believe that we were in violation of the charter based upon the person not being moved and they're not being paid for that position. They're currently
Well, they've been
employed.
paid
They're
by-
currently employed in the mayor's office.
And they've been paid by the city, right?
They're being paid by the mayor's office, not
The
this
city
particular
and the mayor,
position.
they're sort of synonymous, aren't they? Does she have a separate account?
Separate budget.
Argumentative.
I withdraw the question. All right, and then she says, please have Jonathan immediately cease performing the duties that would typically be performed by a civil service employee. Do you see that?
Yes.
Okay, and did you weigh in on that and suggest that that person then go back to the mayor's office until certain civil service compliant requirements were met? Did that happen, to your knowledge?
As I stated, I did not respond directly to Director Gray on this email.
Okay, fair enough. And to your knowledge, nobody in the mayor's office did?
This was not directed at anyone in the mayor's office. It was sent to Director Coyle.
Sarah Baker was copied, right?
That's correct.
You were copied, right?
That's correct.
You're the mayor's chief of staff, right?
Yes,
Okay, so you were made aware of it, and you're a representative of the mayor's office, right?
I am.
Okay. Now let's talk about that delegation of authority again. I think you testified it was signed on the same day as the letter that was sent to Director Sonia Jenkins Gray, correct?
I'm sorry, say that one more time.
The delegation of authority that we talked about, that's dated August 23rd, 2024, is dated the same day as the letter delivered to Director Sonia Jenkins Gray with respect to pre-termination, correct?
I'm trying to remember the day that she received her pre-termination letter.
Okay. All right. The records speak for itself. Did you have any discussions with the mayor about the delegation of authority?
I think just ensuring that it was up to date.
Tell us about those discussions. When did they happen?
On or
I
around.
object. I mean, this is getting into repetitive testimony. When he was on the stand before, he testified at length about the delegation of authority, and we're running back over old ground.
He did not talk about discussions he had with the mayor about the delegation of authority, because I never asked him unless you did.
Well, you're requesting hearsay testimony now.
I'm not requesting hearsay testimony.
You're asking for conversations with the mayor, so
Right.
So out-of-court statements that you're.
It's not offered for the proof for the matter asserted. It's offered to determine whether or not the delegation was a proper delegation.
All right,
And that's
wait,
what
wait,
we're
wait.
going over.
The issue you're talking about is a delegation of authority. We did hear a lot of testimony about it before. There was a document introduced that was a delegation of authority form that was used.
Yes.
And in fact, I think there were two documents, two
Yes.
different times. And there was a lot of testimony about those.
Right.
Now, how is that delegation of, and that was, both of them related to a delegation of authority to, one of them was to Mr. Boyd, I believe.
For mayoral employees and personnel. That was the first one.
And the other one was what, refresh my memory.
That was the one dated August 23rd, 2024, that specifically changed the language to include appointees of the mayor, which would have swept in the director of personnel.
All right, and how is this relevant?
Well, it's relevant in two matters. First of all, it shows that the investigation was conducted without the requisite authority, because he didn't have it. So we had whatever number of days, short as they were, where he was investigating without any legal authority to do so. That's number one.
How does the commission get involved in a question of whether or not there was a proper delegation of authority?
Well, the commission is charged with trying to determine whether or not this is a bona fide investigation based upon the evidence that's going to be presented, which includes the fact that the documents show that he had zero authority to do anything he did at the time he delivered the letter.
So you're saying that the second one, the August 23rd one, the letter, refresh my memory, what was the date of the letter, the pre-termination notice letter date?
Exhibit 1 in the binder
Exhibit 1.
is the notice, the appointing authorities binder, is the email transmission Friday, August 23rd, 2024, with respect to the notice of charges, let's call it that. And then, in that same binder, exhibit number 11, is the report of delegation of authority dated August 23rd, 2024. And my only question I'm asking, I'm not going to reply old ground, I'm just trying to figure out what they discussed in that regard, because that's germane, in our view, to what the true intentions were.
So it does call for
But
hearsay.
we have a document that says there's a delegation of authority dated August 23rd, and a document that has a notice given on August 23rd.
Yes. And the investigation predated both documents.
All right. So you're saying that there has to be a delegation of authority from the mayor to his chief of staff or her chief of staff or to any other person working in the office
Well,
to investigate these allegations once they come to light?
Well, what we're saying is that, according to what counsel has argued to the tribunal, that the mayor has this all-encompassing authority to investigate anybody that she appoints. And that according to them, that authority is vested by charter, is what they've argued before the tribunal. Until, well, there are two issues. Assuming that authority can be delegated, and we take issue with that. I have a case that's directly on point by the Missouri Supreme Court, A.R. Pearson versus the City of Washington, 439 Southwest 2nd, 756, that calls into question whether or not, when the charter says the mayor does something, whether or not she can delegate that authority to him. That's the first issue.
You just cited a case. Is that in one of your briefs that you've submitted?
No, it's just in my hand.
You just happen to have a case in your hand, which congratulates you for, but can you provide a copy of that to the commission?
Oh, yes, we have copies.
And
We have paper.
And so you're saying that what this case that you're giving us a copy of, which is a Missouri Supreme Court, I'm sorry. Missouri Supreme Court, Pearson versus City of Washington, 1969, you're saying that this case establishes what?
It supports the proposition that the mayor doesn't have the authority to delegate this particular matter to a subordinate. That's number one. But number two, I haven't even gotten to that issue yet. The first issue is that assuming she had the power to delegate that authority, the fact that it wasn't done until after the investigation was completed calls into question the entire investigation. It was improper. Anybody could have started investigating anything, but without a proper delegation of authority, it's not worth the paper it's written on. But this case, the second issue is, can you do it at all, given the charter language? And this case, we believe, suggests that you can't. And so that's an issue, and we should be able to make a record on that issue. And if the commission feels that...
You're doing that right now, aren't you?
Yeah. And if the commission feels that they're not the responsible party, then we make an offer of proof through his testimony about that delegation issue and present it to somebody that does have the authority to make that legal determination.
You're suggesting an offer of proof as to what evidence are you suggesting that you want to offer?
He's objected to the question that I posed regarding the delegation of authority and discussions with the mayor about that delegation of authority.
All right. So you want to offer, what do you think would be the evidence if he were to answer the question? That's your offer of proof.
Here's the chicken and egg problem, and here's where we're bordering on due process. Under the rules, we can't take depositions. Under the rules, we can't get investigatory subpoenas. So under the rules, we find out about the evidence here under oath in this proceeding. And what we do know is that we have a delegation of authority that was signed after the investigation was completed and contemporaneously with the letter suggesting that there would be a public hearing on the notice of termination. That is fundamentally problematic on multiple levels, but under this case, it's problematic with respect to the ability of the mayor to pawn off her charter-appointed duty to an underling. No offense, but someone who is
What's the mayor's charter-appointed duty that she's pawning off?
I don't agree with it, but they have argued up and down the line that the mayor in the charter has all-encompassing authority over all city personnel.
It's authority, not duty.
Well,
there's two different things.
Responsibility and the ability to investigate.
That's another different thing.
Right. This is
now
what
we've got apples, oranges, and kumquats.
Well, and those are all his apples, his oranges, and there's a few bananas in there too. Okay. So this is their argument. I don't agree with it, but this is what they've argued throughout.
All right. I'll tell you what. It's 5:01. So we started talking about this at about 5 to 5. So that means you used up 26 minutes of the 35.
Yes.
9 minutes left.
Yes.
Now, you've given us this case.
Yes.
I'm not aware that you have filed any motion or any brief that sets out how this case is applicable to these proceedings.
It's just come up.
Okay, that's fine. What I'm saying is, you don't have to.
Yeah, we
You're
can
not
submit
required
some-
to.
we'll submit.
But if you want to try to put, your argument as to what this has relevance here into writing, you're welcome to do it prior to the next hearing, which is next Monday.
Yes, and we'll do that, Your Honor. Thank you.
In order for the commissioners to review it,
Yes.
they'd have to probably get it Friday.
Well, we'll get it in time for council to respond to it, because we're not trying to pull a fast one. We just want to comply with the law.
Well, we've got the witness on the witness stand, and obviously we would need to make a ruling on this. I'm just saying, we don't need anything in writing to make a ruling. You pretty much know what the ruling I would make is as of right now from what I've said.
Well, I'm not
But
trying
I'm
to.
just saying, if you want to try to put in a little bit written form.
Yes.
Your argument so that we can consider it.
Yes, we'll do.
You do so.
We will do.
Now, the other thing I'd ask both sides to do, because these are very important issues for the decision in this case, is that, as both of you have alluded to, the city charter provisions, first of all, provide that the director can be removed for malfeasance. But the charter does not attempt in any way to further define malfeasance. I'm not aware of its definition in any applicable city civil service rule or administrative regulation number 117 or any of the other various rules that might be applicable here. So, the commissioners, as you say, have to decide the factual questions of what occurred, and if that then meets a definition of malfeasance. So both of you should, I would think, again, I'm not required, you don't have to, but the commissioners are going to decide this. So if you want to provide us with a brief as to what malfeasance is, that's number one. And number two, along the same lines, we overruled the appointing authority's motion earlier today, trying to exclude evidence of political reasons, motivations, interference. We overruled that based on the city charter provision in section 7 of Article 18 that says, among other things, that the commission shall reinstate any employee who's dismissed or disciplined because of political reasons. And understand that that is not precisely applicable to the situation that we have here. But on the other hand, you've made other arguments in your briefs about why that should be applicable. So I think both of you should brief, number one, what is meant in the charter by political reasons, because once again, the charter itself doesn't define that. And I don't, again, know of any place in civil service rules or anywhere else where it's defined. So I invite both of you to brief both of those issues, because the commission will need to decide that as a part of this proceeding, of their ultimate decision. As both of you have pointed out, whether or not there was malfeasance is one critical issue, major issue, clearly that the commission has to decide, okay? And the second one being your defense of, well, it was done for political reasons, right?
Yes.
All right, so those two terms are very significant, critically significant. Our next meeting is set for next Monday at 10 o'clock. And Tuesday, we have set aside starting at 10:30. And I think both days we can go till 5. Both days till 5. So both days then on till 5 o'clock, if needed.
I'm sorry, can you say
Monday, what time?
Monday at 10,
At 10.
Tuesday at 10:30. Okay? All right. Now, as far as the briefs, if you're going to submit anything on this case, other than the case, you could just give us this, we could review this, and, you know, that,
Yeah, if we will,
submit
put
something.
something together, and we will make sure we get it to the commission. What's today, Tuesday? We'll get it to the commission by Friday.
Okay.
Give a copy to council, so that
Okay.
they have time over the weekend to respond. They have the case, so they can start now. And then we'll be able to address that in the remaining minutes I have with this witness.
All right. Now,
Can I just get some more clarity on
Yes.
on this case?
Yes.
Like, what's the motion here? What's being,
it's not a motion. I was sustaining your objection, I believe, to the question, did you have any discussions, did you have any discussions with the mayor regarding the delegation of authority? That was the question, and you objected, we stopped there, and as part of his response to your objection, and I believe your objection was relevance, wasn't it?
yes, it was relevance. and
Okay.
Yeah, it was relevance and hearsay, but yeah.
Well, he would say, the case is a case. I don't, anyway, the case isn't hearsay, right? Discussions with the mayor is what you're talking about, hearsay, right?
Correct.
Okay.
Correct.
At any rate, relevance issue, and Mr. Norwood cited this case and said that this had applicability. And that's where I
Okay. so
said,
just-
obviously, first time I saw the case, so that's where we're at. Does that answer your question?
I think so. So, yeah, so I guess he's gonna, if he may brief something to show why that question is proper.
Right. Okay? So that's where we're at?
Yes.
And Mr. Boyd is still on the witness stand. So, Mr. Boyd, can you be back here 10 o'clock on Monday?
Yes.
Okay, great. Thank you, Mr. Boyd. No, you got a busy schedule too, so appreciate that. All right, then, I think we're done for the day.